All right, folks, we need to get going. We have a quorum, I think, here, so the clerk will call the roll.
Yeah. Mr. Chair, you have a quorum.
Thank you, Mr. Jackson. Why don't you text him and call him? Text him and call him, check. Thank you. All right, folks, I have a couple announcements before we start the committee and a couple bills that are getting by for the day moved around. First of all, not sure if everybody noticed, but there's the next two dockets, this docket and the docket for Wednesday, are already posted online. Want to try and get that out there because don't have a lot of time between Monday and Wednesday to set it. So the thing that the committee members need to keep in mind and patrons need to keep in mind is that we have a deadline next week to get all bills to finance. I think Monday is our last day to put bills in finance, and so we can't keep going by for the day on these bills that have fiscal impacts. The second thing I just want to note, or the third thing, is on Wednesday, I've set the cannabis bill and also second look. I would suggest the committee members look at the cannabis bill sooner rather than later. It has about 30 pages of new criminal text, and the last time that bill went through, it did not make a pit stop in the Courts of Justice Committee, and so it needs to be looked at hard. And the second look bill is going to take some time. The docket might look short, but I think it's actually got some big ones that might take some serious time. So I have 4 bills that need to go by for the day. People want to note this down. First of all, Senate Bill 364 by Senator Eben. I think it has to do with election offenses. Senate Bill 653 is just strike. Yeah, we'll go back to that. Then Senate Bill 654 by Senator Perry, which is the dating relationship bill. And Senate Bill 44 by Van Valkenburg and Eben has to do with access of a firearm by a minor. So the chair, let's see, Senator Boysko moves, Senator Deeds seconds that those 3 bills go by for the day, 642, 44, and 364. All those in favor say aye. Aye. Anybody opposed? No. Okay. And then Senator Durant has asked that 653 be stricken. Senator Boysko moves, Senator Deeds seconds that bill be stricken for the docket. The clerk will open the roll. Huh? What? Sorry, it's Durant's 653, top of the docket on the sheet you passed out. $653. Yep.
Ayes 12, no 0.
Great. So that's it for announcements, preliminary stuff that I'm aware of at this point. First on our docket is Senator French, who I believe has, what has he got? Senator French, come on up. What do you have?
Well, good morning, Mr. Chair.
646.
Yeah, I'm here.
Criminal Injuries Compensation Fund.
Bill 646 ensures that the passage of time will not be a barrier to when the victim can file a claim with the Virginia Victims Fund in case involving sexual assault as a minor. The Virginia Victim Fund is a state program created to help victims of violent crime with out-of-pocket expenses. Currently, for the cases involving sexual abuse of minors, the claim can be filed within 10 years after a minor's 18th birthday. And this is to remove that 10-year. Many victims do not get help until later in life. If there's no statute of limitation on the charges, there should not be limitations on when victims can file assistance. The VBS fund is fines and fees collected from offenders. In addition to federal grants, no Virginia tax dollars are used, my understanding. Since July 2011, VBF has had over 150 claims for victims over the age of 28. This bill will ensure that children who were victims of crimes get to receive the help that they deserve, no matter when they choose to pursue their case. I talked to some people in my district that work within the judicial system, and they felt like this would be a good to take this really just a question so that they don't have to prove on the when they're trying to do something after the age of 28. So with that, I'd like to have the blessing of the committee to pass this bill. I do have some people here to speak on if we have any questions.
Hey, Senator French, I got a quick question. So I think I understand what you're trying to do, but just so I'm clear, if a victim wants to apply for compensation under this fund, the person who was the abuser has to have been convicted first, right?
I think that is true, yes.
Ms. May, do you know if that's true?
Mr. Chair, I'm going to look through. I think that the claim may be able to be filed prior to conviction, but I think it may be kind of continued out until the case is finished. Double check.
Okay. Are there any other questions for Senator French? No other questions? Okay, let's set the timer to 5 and 5. Is there anybody in favor of the bill? Can you please come on up?
If there's anyone online that would like to speak in favor of the bill, please raise your hand.
Good morning, Mr. Chair, committee members. Brandon Robleski, Senior Assistant Attorney General. The Attorney General supports this bill. The Virginia Victims Fund brought us this bill. They are unable to lobby due to receiving federal tax funds. So this bill would simply expand child sexual abuse victims' ability to receive the funds that have already been set aside for them. So I hope it will be the will of the body to report the bill. Thank you.
Thanks. You got one more?
Good morning, Mr. Chairman. My name is Daniel Rutherford. I'm the Commonwealth Attorney for Nelson County. I'm here on behalf of the Virginia Association of Commonwealth Attorneys, and we support this bill.
Thank you. Okay, is there anybody, we reset the timer, is anybody opposed to the bill? I'm sorry, do we have to check online?
There's no one online, Mr. Chair.
For or against?
If there's anyone online that would like to speak in opposition, please raise your hand.
Okay. Anybody in opposition, come on up. Okay. Looks like,
Move to report, refer to finance.
okay, it's been moved.
They asked for it?
Yeah,
Okay. It's got nothing.
yeah, they asked for it, though.
Okay.
Involves money, I guess. All right, so it's been moved and seconded. The bill be reported and referred to finance. Clerk will open the roll.
Ayes 14, no 0.
Thank you, Senator French.
Thank you.
Okay, next up I have Senator Marsden. So we got 460.
Thank you, Mr. Chairman, members of the committee. I believe we have a clarifying amendment to a clarifying bill. If the staff could report.
Well, Clerk, do you want to explain what the Ms. Sabrina explained?
Would you like me
Who's going to explain the amendment?
The amendment to the bill just restates, and they had wanted to reference 16.1336 as a definition for substance abuse that is mentioned in the bill.
Okay, Senator Deeds moves, Senator Boysko seconds the motion to make the amendment. All those in favor say aye. Aye. Anybody opposed? No. Okay, Senator, why don't you explain the bill?
All right, this is a clarifying bill. Basically, when a parent wants to have a young person held in a mental health facility, it does three things, this bill, to clarify. First, it restates existing law that you do not need a temporary detention order, that it can be done without one. Secondly, it requires that mental illness be the issue for putting somebody in a mental health facility, not just referencing inpatient treatment. And thirdly, it adds substance abuse as a reason for that inpatient treatment. So it really just clarifies existing law and allows also for substance abuse to be part of that reason. And all of this is, of course, reviewable by the juvenile court within not less than 24 nor more than 120 hours before the court reviews it and can make a decision and a determination as to what the child's best interests are. And that's the bill, Mr. Chairman. And it's it's a bill that comes out of the Commission on Youth after considerable review.
Okay, this bill's been heavily vetted by the Commission on Youth.
Yes, sir.
And does anybody on the committee have any questions for Senator Marsden? No. Okay, is there anybody in favor of the bill? Anybody opposed to the bill? Anybody online about the bill? Let's see. Does it have to go? Nope, does not. Okay. It's been moved and seconded. The bill be reported. Clerk will open the roll. Great.
Ayes 14, no zero.
Thank you, Senator.
Thank you, Mr. Chairman.
Okay. Next up, we have Senator D-Staff. And Diggs right behind him. Senator D-Staff, you talked maybe about either rolling your bill with Senator Diggs, or I'm not sure they'll take a long time. But
Whatever you want to do.
It's up to you. I don't mind.
Yes, let's do it.
Let's roll them together, Mr. Chair.
who's going to
I think
who?
they're probably going to come the same outcome in the end.
Who wants to roll to who?
Let's roll my bill into his, but let's use the text of my bill.
Okay, so we're going to roll Senate Bill 221 into Senate Bill 203, and we're going to conform Senator Diggs' bill to Senator D-Staff's text, right?
Perfect.
Okay, it's been moved, and Senator Boyska moves, Senator Deeds seconds. That we do that, the clerk will open the roll.
Ayes 14, no zero.
Great. And MJ, do we need a motion to conform? Are we good? Can we wrap that all in? Yeah. Okay. Do we need a verbal motion to conform? Okay, so Senator Boyska moves, Senator Deeds seconds, that we conform Diggs' language to D-Staff's 221. All those in favor say aye. Aye. Anybody opposed? No. Okay, Senator D-Staff, why don't you explain what's now Senator Diggs' bill?
Mr. Chairman, members of the committee, Senate Bill 221 provides that a person who's guilty of a separate felony, first day with the new lips, I'm still working on that. If he carries about his person any pistol, shotgun, rifle, or other firearm that's hidden from common observation while committing or attempting to commit certain other felonies. And we can go into the specific felonies. We list them out in the bill. And that's the first part of the bill. Then the second part of the bill, if you're caught concealing a weapon and you're committing that felony, then the minimum increases from 3 to 5 years and then from 5 to 10 years for a second and subsequent offense. The police officers, detectives, forensic professionals represented by the Virginia Beach Police Benevolency Association. We've had about 8 other associations sign up and say they'd support the bill as well. So with that, Mr. Chairman, I'm happy to answer any questions. If you want to know the specifics on which acts, I'm happy to go through that. It's rape, murder, forcible sodomy, inanimate or animate object sexual penetration, robbery, carjacking, murder, malicious wounding, malicious bodily injury to a law enforcement officer, aggravated malicious wounding by mob or abduction. So we can kind of go into many more if you'd like, but I think you kind of get the gist of the bill.
Thank you, Senator. This bill is basically identical to the bill we PBI'd last year, 9-6, right?
Yes, sir. That was Senate Bill 1378.
Great. Okay, it looks like Senator Perry has a question for you.
Mr. Chairman, Senator D-Staff, I just have a question. It looks like from your bill, and I think the difference between your and Senator Diggs' bill is twofold, but I think in looking at the language of your bill and the concealed carry part of it in particular, I went back and did some case law research last night, just looking at the word, use in the commission of these variety of felonies and trying to think through how that applies. But to be honest with you, I think you can still be convicted of this charge and conceal your weapon. You can still use it in the commission of a felony and conceal it. And the reason I think that is that there are a number of cases where someone will have a concealed weapon on them. They will go to commit a robbery, for instance, right? And the weapon will remain concealed throughout the course of the robbery, but they will point to it, they will reference it in the course of the robbery. And there are folks who have still been convicted of use of a firearm in the commission of a felony as it stands now, even though the weapon is concealed. So I guess my first thought is I don't know that this changes the law at all. and at least as it relates to the use of concealed while someone uses a firearm in the commission of a felony. I think there's a second issue, whether it's 5 years or 10 years for a first or a second, but that conceal is interesting. And I guess my second question, Mr. Chair, I'll let him answer that question.
Mr. Chairman, if I may, Senator Perry, so the difference before, it's in a threatening manner. So the existing law talks about how you're doing this in a threatening manner. With this bill, you just have to carry about on your person and have that hidden from common observation. So the initial situation you're talking about, existing law says if you reference to that, if you show it, if you expose it, if you say, hey, I have a gun, and mine specifically says that if it's hidden from common observation. So it's that and, I'm sorry, that or that. So it can be either or, and there's no confusion. If you have that concealed weapon on you, you're going to get hit with a separate felony.
Mr. Chairman.
Senator Perry.
And then my follow-up question to that is, if that is your intention and the intention of the bill, then I guess my follow-up question is, what does concealment have to do with anything? What is it about concealment that raises concern? Why wouldn't you have it be possession of a firearm in the commission of any of these felonies? Why does the concealment, doesn't that, if anything, if nothing else, doesn't that make it less concerning? Like the concerning part of this bill, right? The reason for 53.1, right, is that someone is brandishing it, right, in the course of these most serious of cases. And so if it's concealed, if no one references it, if no one uses it, certainly introduction of a firearm into any of these situations is dangerous. But why the conceal?
Mr. Chairman, Senator Perry, if I may, I'm going to hand this over to my subject matter expert on this, our former Sheriff, Danny Diggs.
Senator Diggs, you want to explain your new bill or answer the question on your new bill?
Yeah, thank you, Mr. Chairman. I think what this additional phrase does is actually clarify the point that you made in your initial comments. I certainly could have a weapon on my side now and do this, and my coat may just flash open, and that would be enough to intimidate. I mean, you mentioned it. You never have to display it, and I think some prosecutors and or judges would like this additional language to clarify the point that you didn't actually have to brandish a firearm, but you could merely have it, about your person. So to me, it clarifies that distinction that you made in your opening comment question.
Senator Diggs, so I remember about 3 years ago, I had a guy up in the gallery who had just been released for, I think it was 3 robberies and the 3 strikes and you're out law that I think Senator Saslaw passed that the parole board interpreted you had to be at liberty between. But when I was reading about what he did, apparently he either had his hand in his pocket or his gun in his pocket. And all he did was kind of move his pocket and without displaying anything. And he ended up getting convicted of a felony. I mean, wouldn't that be, although not displayed, enough to intimidate?
Yes, sir. Mr. Chairman, you're correct. I think Senator Perry is correct. And I think for those judges who may want a little more than the brandishing definition, this takes care of that and clarifies it. And really, other than clarification, I don't think makes a whole lot of difference. I just think it's a point of clarification in case someone was to rule otherwise.
Senator Perry, you have more questions?
I was just going to say, I think that's already the law, right? And so as attorneys, we look at not just the statutory language, but we go and look at the case law. And there are numerous cases. I think I pulled up Barnett last night, but it's not uncommon or unusual. It's a reported case out of the Court of Appeals. So I would just suggest this is just a restating of the law. I don't know about any judges feeling in one particular way or not. They also too rely on case law, as do the attorneys who appear before them. And so I think the word use, which is kind of an uncommon word in the criminal law, encapsulates that as well.
Okay, thank you, Senator Perry. Senator Diggs, I never gave you a chance to explain what's now your bill. Is there anything else you want to say about it before we take testimony?
No, sir. Other than the additional part about the changing of the penalty, it moves it from 3 years from an initial offense to 5 years, and then on a second offense moves that penalty from 5 years to 10 years. I understand how somebody could get mixed up and do something really stupid or be mixed up in the wrong crowd and making it on a first arrest for an armed robbery as such. But when you're using a gun on a second offense for an armed robbery, that's not a mistake. That's an intentional act. You've already demonstrated once that you were willing to put a gun in somebody's face or use a gun in these various crimes. A second offense is certainly intentional, no accident whatsoever, and should be, in this day of age with violent crime on the rise, we certainly need to send a message that we mean business, and I think a 10-year sentence for a second offense is certainly a reasonable penalty.
Okay.
Mr. Chairman, members of the committee, I did see that there's a $6 million impact on this. I did actually put a budget amendment in, and I believe last year when we challenged this, it was reduced, so I'll probably request that it get challenged again, and I'm sure it'll get reduced substantially again.
So let's set it for 5 and 5. If there's anybody to testify, is there anybody here in favor of the bill?
If there's anyone online that would like to speak in favor, please raise your hand.
Mr. Chairman, members of the committee, Josh Humphreys, Deputy Secretary of Public Safety. The administration supports the bill.
Mr. Humphreys, did the administration put this in their budget?
We did not, Senator.
Okay, thanks. Anybody else in support? Anybody online?
Mr. Chair, there is no one online to speak in favor.
Okay, anybody in opposition to the bill?
If there's anyone online that would like to speak in opposition, please raise your hand.
Okay. Final word. Any further debate? Oh, I'm sorry. One in opposition.
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. We oppose both of the bill's languages for different reasons, mostly the ones that were mentioned by...
Can you lean into the microphone, Mr.
sorry.
Goddard?
Most of the reasons we oppose it were mentioned by Senator Perry, but we also have a position against mandatory minimums anyway.
Okay. Next up, Moms Demand Action.
Good morning.
Can
My
you lower
name
the
is...
microphone so it points at your mouth? There you go.
Thank you, Mr. Chairman and committee members. My name is Mary Ann Resson, Fairfax County, and I'm a volunteer with Moms Demand Action for Gun Sense in America. We oppose this bill. We oppose mandatory minimum sentences, as research has consistently found that they do not have an impact on violent crime or crime overall, and they can exacerbate disparities in the criminal legal system and disproportionately impact Black and brown communities. Thank you.
Mr. Chair. Could that testify? Could the witness return for a question? Thank you, Mr. Chair. So I heard your question on mandatory minimums in regards to this bill. If the purpose of Moms Demand Action is to make sure that we work on gun violence prevention measures, if someone committed a crime with a gun and they were facing possibly or may not commit a crime with a gun, have you thought about the deferred crimes that may not occur based off of a mandatory minimum? Have you taken that into your thought process?
I'm not sure I understand.
For instance, you oppose mandatory minimums, which seems counterintuitive to your position on gun violence and reducing statistics. So you're using data that says that mandatory minimums somehow do not prevent crime. Have you thought about that if the mandatory minimum of 5 or maybe a subsequent offense of 10 years may defer someone's action completely? And how would you account for that data since your goal is to prevent gun violence?
Well, we consistently support, based on research, legislation that prevents gun violence. And from Everytown's research, they do not see this outcome, this bill, as preventing gun violence.
Follow-up question, Mr. Chair.
Yes, Senator Jordan.
Follow-up question. I understand that there is somewhat research. We always know research can be skewed, but I'll take that to the side. So there is no research, I'm sure, that says that if someone was afraid of a 5-year minimum sentence, there would be no way to track that, right? But, you know, if we tell a child they can't have candy before dinner, otherwise, you know, if they see any candy, they can be punished, it prevents the action, right?
Mhm.
So would the thought be that maybe if we had a mandatory minimum, something like this, it might prevent the bad behavior so that way you don't have to worry about the statistic? It's just a thought. Thank you.
Thank you.
I would just add to that. I'm sorry, I'm Lindsay Lang. I'm also with representing Moms Demand Action. And if it's okay, I would just like to respond that we do have the research that shows that the mandatory minimums are not effective. And I know that they can be debated. But you know, the mandatory minimum is in place today. This would be increasing it.
Mr. Chairman.
Thank you.
More questions from Senator Stanley.
If the witness would return to the stand, I mean, to the dais.
We know what you mean.
Good morning.
Your Honor.
Mr. Chairman, I'd ask the gentlelady, it seems hypocritical to me that you're against mandatory minimums for someone who gets convicted with concealment of a firearm or use of a firearm in a felony. That would, in a second offense, not a first, a second offense, that would actually take them off the street so that they could not commit crimes again for at least 5 years. Can you explain how you balance what I think sounds hypocritical?
It does sound counterintuitive on the surface. I understand that, and we are here in support of a number of other gun violence prevention measures. It really is the minimum mandatory sentencing aspect that we are in opposition to.
Mr. Chairman.
Senator Stanley.
I'd ask the witness again. Why would you be against putting someone in jail for a long time for using a firearm, something that you're here to prevent the use, especially after the second time that they've done that? Why do they not deserve at least a minimum sentence of 5 years or more?
Well, there is already a minimum sentence in place today, and we just feel that it is something within the legal system that can exacerbate disparities and don't feel like it's the most effective measure at gun violence prevention.
Mr. Chair.
We're just going to agree to disagree.
No, Mr. Chairman, one more question.
Debating witnesses.
No, I'm not. Mr. Chair, I'd ask permission to ask this
Mr.
question.
Senator Stanley.
Okay. Based on your answer, can you tell me why we need to be, and especially with the position that you guys take, and I understand it, why we need to be gentle with someone who is convicted of possessing a firearm and its use in a criminal felony, and we're talking about felonies like rape, murder, carjacking, burglary, malicious wounding. I could go on and on. Why aren't we, if they're the second time with the firearm that you hate, and they're convicted with a violent act against a person, why are we not saying you're going to spend at least 5 years in the penitentiary for doing that to another human being?
I'm not suggesting that we go easy on them. I am not a lawyer, but I do feel that this would really just be putting in that minimum. It's not saying that every case can't be decided and that person cannot get that deserved penalty. It's strictly just having that minimum, increasing that mandatory minimum in law.
Okay, thank you, ma'am. Next.
Thank you.
Good morning. Rob Pogenclass from Justice Forward, Virginia. We also oppose the penalty aspect of the bill, and I would clarify something that's come up with Senator Stanley's question, talking about the second offense being a sort of recidivist offense. In my experience representing children accused of crimes like robbery, you have multiple guns being used by other individuals, and one person can be charged with 3 charges of use of a firearm during the commission of a felony for the same robbery. So you can be charged with 3 counts if there are, say, 3 victims, or if there are multiple people with guns, you can be charged with each count of having the gun. So we're not talking about repeat offenses necessarily. We're talking about one person and either multiple victims or multiple guns at the scene. And under this bill, you could have one person getting 25 years if there were 3 victims in the same crime. I've represented people in those cases, kids. So we oppose the bill. Thank you.
Next, there's somebody online, I think.
Mr. Chair, there are 2 people online that would like to speak. Kelly Sampson, please unmute and make sure your camera's on.
Good morning. My name is Kelly Sampson. Can you hear me?
Yes, ma'am, we can hear you. Talk.
My name is Kelly Sampson. I'm Senior Counsel and Director of Racial Justice at Brady. While we appreciate the sentiment and concern for reducing crime, as that is our mission as well, we do oppose the bill because of the mandatory minimum sentences. The reason why is because troubling patterns have emerged when it comes to mandatory minimum sentences and gun violence. For example, the Michigan felony firearm statute, which was enacted in 1977, required a mandatory 2-year prison term for those who had used a firearm in commission of a felony, but the law didn't increase the probability that a prison sentence would be imposed. It simply increased the length of the sentence. And we know from research that the deterrent benefits come from the certainty of punishment rather than the severity or the length of that punishment. And it doesn't really impact the type of violent crime. Furthermore, we know that a U.S. Sentencing Commission report showed that prosecutors use charges that carry mandatory minimum sentences tactically to obtain guilty pleas from defendants. And this is a way that exacerbates existing racial disparities. And we know that when it comes to mass incarceration and the like, it actually can destabilize communities in a way that can further increase gun violence. So because the law already exists on the books, what we would ask is that the law would be enforced as it is, because it's not necessarily the length of the prison sentence, it's the probability that it will actually be imposed. Thank you.
Thank you, ma'am. Next.
Ramin, you may unmute, and please make sure your camera's on.
Good morning, members of the committee, Mr. Chair. Ramin Fadahi, I'm the Commonwealth's Attorney for the City of Norfolk. I hadn't intended to speak on this bill, but there were a couple of pieces of data that I wanted to offer. Senator Diggs had mentioned that crime and violent crime are up. The preliminary FBI data for the year 2023 shows the largest year-over-year drop in violent crime that the FBI has ever recorded. I'd also point out
Your time is up. Could you wrap it up, please?
Yes, the judges don't need mandatories to lock people up for life. I oppose the bill.
Thank you, sir. The bill's before the committee.
Mr. Chairman, if I can just wrap up real quick.
Okay, if you wrap it up real quick.
Just to answer a couple things, this doesn't put people away for life. This says if you use guns in the commission of a felony or have a gun on you in a threatening manner when you're committing a felony, then we want to make sure that you're punished for that. So you either, I guess, like guns or you don't like guns when you're committing a felony. We've went with the most harsh crimes here. So these are bad people doing bad things. And I just believe that if they're hiding a weapon when they're doing it, they should be punished in a bad way. So thank you, Mr. Chairman. I think my co-part on this one may have something good to say as well, or bad.
Mr. Chairman, thank you. It's just, if we're going to be serious about gun violence, violent crime, we need to have substantial penalties. And I think Senator Jordan's point was it's very hard to measure how much of a deterrent a preventative measure is by imposing a stricter penalty. We certainly think it does, and we hope that the committee would pass the bill. Thank you.
Okay, Senator Jordan has something to say.
I just would like to speak to the bill at the appropriate time, so if there's still questions.
That's the appropriate time. Not going to get more appropriate.
Wonderful. Thank you, Mr. Chairman. Just speaking to the bill on this, first, I appreciate the patrons bringing forward the bill, but, I listened to all the testimony. I listened to, folks that were worried about the disproportionate rates of people being, quote, targeted. But I think at the end of the day, we have to look at something very specific here. We're not talking about targeted people. We're talking about targeted victims. We're talking about rape, robbery, murder, other serious offenses. And if mandatory minimums are a deterrent, which I believe that they are, to making sure that people don't get themselves in the crosshairs of someone that might commit a rape, a robbery, a murder, or other serious things like carjacking, I don't know what the fear of this committee would be to shy away from using tools in a toolbox to ensure people are not committing crime. I don't know what is so scary about that. And so, I really hope the committee takes a serious look at this and not just listen to, statistics, because there's no way to put a statistic to prevention. Thank you, Mr. Chair.
Thank you, Senator Jordan. Senator Peake.
There we go.
Mr. Chair?
Thank you.
Mr. Chairman.
Okay.
Yeah, thank you, Mr. Chairman. Speaking to the bill, it's kind of shocking when you look at the bills that we have seen this year about gun violence and all the bills to take guns off the streets and actually to make certain types of guns illegal. We even have a civil penalty for leaving a gun in your car. And we have multiple bills to make it mandatory that you lock a gun up in your own house to prevent, as the sole purpose of those bills, we're told, is to prevent gun violence. And here we have a bill that is targeted at gun violence, to stop gun violence. And people talk about deterrent. Well, it's not just about deterrent. These people have committed the most violent crimes and are recommitting the most violent crimes. And if it doesn't deter them, I tell you one thing that is a fact for sure. If they are in prison, they are not committing crimes against innocent citizens of the Commonwealth. All this talk about gun violence and preventing gun violence, and here we want to punish the people who are actually committing the gun violence. It is a good bill. I support it.
Okay, Senator Carol Foy.
Thank you, Mr. Chairman. Just very briefly. So, speaking to the bill, I do take objection. I do think statistics matter. I think that evidence-based decisions matter. I know the fact that studies have shown that it's not, as been stated, the amount of time that a person's facing, but the certainty of time. That is the real deterrent, that if you commit a crime, it will be investigated, you will be arrested, you will be incarcerated. That is what works. We have continuously subscribed to this tough on crime talking points and policies that's been completely ineffective. And where we are now is, why do we want to impose more mandatory minimums when the studies and evidence show that it's not as impactful as people would like to believe? So I understand that people believe in their own life more punishment is a deterrent, but it's not, and the evidence speaks otherwise. We have one of the lowest recidivism rates in the nation, so where we are now, the status quo is working. There's no need to have more of these policies that seek solely retribution. It's not a good deterrent, and we need to trust our judges. Judicial autonomy is important, and mandatory minimums undermine that policy. So in that, I will be not supporting this bill.
Senator Obenshain.
Mr. Chairman, you know, one thing that just astounds me is that the advocacy groups who come in here every day supporting every single piece of legislation targeting law-abiding gun owners, supporting every single piece of legislating, and it may be really funny, sir, but it's amazing to see them come in here today and oppose a piece of legislation targeting criminal gun owners. I move to report.
Thank you, Mr. Chairman. I was in the queue for a while, but somehow got overlooked. There was a lady who spoke on video, and then Senator Carol Foy, both of whom I respect a great deal. But their point was that certainty of punishment is the only thing that works. Well, a minimum mandatory is certainty of punishment. People know that if they commit a crime with a gun, if they murder someone, if they rape them, if they rob them, they're certain to get a minimum mandatory sentence. And I don't often say this, but I have to say today the abject hypocrisy in this room is astounding to me. These groups that come in here day after day and support bills that target honest, law-abiding citizens, gun owners, would stand up and oppose a bill to hold a criminal accountable that uses a gun. It is truly astounding, but I tell you what it does. It absolutely illustrates what your true purpose is here. and that's to take guns away from honest people, and you ought to be ashamed of yourselves.
Okay, we had a motion to report that was seconded, then we had substitute motion to PBI that was seconded. Substitute motion takes precedent. Please open the roll. PBI.
Ayes 9, no 6.
Okay, ayes 9,
Mr.
no
Chairman,
6.
members of the committee, thank you very much for your
Thank you
time
so
today.
much. Okay, the next non-member bill is Senator Williams-Graves.
Good
And I
morning,
think your
Mr.
bill is
Chair.
514, is that correct?
I have two. I have 514 and 654. We can start with 514.
It's 654 on the docket. It is. Okay, yeah, it is. Yeah, I see it. Okay, 514.
Thank you, Mr. Chair, members of the committee. Senate Bill 514, which reduces the period of limitations for the collection of court fines and costs. There is an amendment.
Mr. Chair, I will orally report the amendment. There's a few amendments. It's on line 27 of the bill. It would, after section 19.2-341, it would strike the remainder of that line and all the way through and on line 28. And then it would also strike extinguished on line 29. And then it would make similar amendments starting on line 46. After subsection A, it would strike the remainder of line 46 and then all the way through and on line 47, and then strike extinguished on line 48.
So what would be the net effect of the amendment?
Mr. Chair, so that subsection B in each of the code sections would now read, notwithstanding any other provision of law, upon the expiration of the period of limitations, no action shall be brought to collect the debt.
Okay. You've heard the amendment. I apologize. Senator Williams-Graves.
Thank you, Mr. Chair. This bill, Senate Bill 514, is an effort to make sure that court costs, that court fines and fees do not result in a lifetime sentence to poverty. Specifically, this bill would shorten the statute of limitations that applies to the collection of court debt, bringing Virginia in line with several other states across the country. But first, I'd like to highlight that Virginia is a national outlier on this issue. The statute of limitations that applies to court fines and fees is, for example, 10 years in West Virginia. It's 10 years in Washington State, 10 years in Arkansas, 10 years in Tennessee, 10 years in Texas, Oregon, and 10 years in North Dakota. But in Virginia, it is up to 60 years.
Let me ask you, Senator Williams-Graves. So if a person's got a 20-year sentence, they've got to pull 20 years. Their statute of limitations runs while they're in prison? Before they're ever incarcerated, before they can ever pay a cent, the statute of limitations is gone.
That is not a question I am sure of the answer of. However, in the bill that I'm about to bring, we address when collection of court costs and fines can be established so that individuals are not sent to collections for court costs and fines while they are incarcerated. But I cannot speak to that question in this particular bill. Maybe the legal minds can do that.
My only point is, I think the statute of limitations runs before people are really able to pay the fines. Is that
Senator
correct?
Dietz, I thought about that too when I was looking at this, the longer prison sentences and what that would mean. But what I took solace in, and I could be wrong, is the sentence in at least subsection 19.2.341A. And I apologize, a little hard for me to track all the amendments that are made orally. Never was an oral learner. But it says, at the end, it says judgment. So it appears that within 10 years from the date of judgment. And so I take that to mean not from the date of conviction, but from the date of our courts would enter a civil judgment if certain fees, fines were not paid. And so I took it 10 years from the date of when the court entered that judgment.
But in a criminal case, isn't the final order of conviction the judgment?
It wasn't in my courts, Senator Deeds. It was what would happen is they would have a final order of conviction, right, entered 10 days after you're sentenced or whatever else, and then they would be, sentenced to pay $1,000 in fees and whatever, $1,500 in court costs or whatever. And so after they got out is when their probationary period would start, and so they would be required to pay. If at some point we decided we're just coming back on fines and fees, then the court would enter a judgment against them. And that judgment then is what I took this to mean.
Point me to the code section that says that's what the court does.
Well, I'm happy to be counsel for the Judiciary Committee, Senator, the Courts Committee.
Maybe you can help me.
Mr. Chair, it is my understanding that the statute of limitations does not toll while someone is incarcerated. And perhaps OES can correct me if I'm wrong, but it's my understanding that it would not toll while they're incarcerated. So if they were incarcerated for longer than 10 years, then the fines would be extinguished. I know we took that language out. I'm thinking about what Senator Perry's saying, and I'm looking at the language, penalties imposed and costs taxed in any proceeding shall constitute a judgment. So it is my understanding that it would not toll.
Well, that was my understanding too, Blair. Okay.
Are we all clear as mud?
Clear as mud.
Clear as mud. Great. The one other thing I'd like to stress is that Virginia's laws do the most harm to folks who are least able to pay. That means if someone is looking to pay their court debt immediately, there may be some issue with that. But if you can't pay right away, let's walk through that. For starters, if you need more than 90 days to pay the court charge, there's an additional fee. Each payment that you make with your debit or credit card adds an additional fee. From then, if you want to get a payment plan, you may have to hand over as much as 10% of the balance of what is owed. And then let's not forget that interest kicks in after 180 days, which we do seek to remedy in the next bill. It's also important to note that this piece of legislation brings criminal collection in parity with civil collection of court costs and fines and does not include restitution of payments in any fashion.
Questions for Senator Williams-Graves? Are there those here who would like to speak in favor of this bill?
If there's anyone online that would like to speak in favor, please raise your hand.
And I want you to be able to tell me why we shouldn't toll the statute of limitations while they're incarcerated. 5 minutes each side.
Thank you, Mr. Chairman, members of the committee. My name is Emily King with the Commonwealth Institute. We support this legislation. Thank you.
Thank you, Senator Deeds and members of the committee. To specifically answer that about the tolling, it does, the way that the bill is written now, toll while somebody's incarcerated. And I think that is the right result, because if somebody's serving 20 years, they're facing so many...
Point me to the language where it tolls 10.
Well, just the idea of the judgment. I think that, no, I'm saying that it does not toll.
Okay. Well,
does not toll. Yeah, so because in recognition of the idea, if somebody is serving such an extended period of incarceration, they're going to face huge burdens and hurdles upon reentry, that having that extended cost. You all heard from Hassan Shabazz last time at the very end of the night, but he talked about he served a 23-year sentence, and the reason he's been able to come back and immediately help give back to the community, set up community projects, work with his community is because he hasn't had to deal with those burdens. So I think that is the right result, and that is the result of the bill, and that's why we support it.
No, Mr. Chair, Dominic Martin, New Virginia Majority, and for the reasons just stated, we also support the bill. We would like to see people being able to come back into society and avoid these poverty traps that come with the fines and costs associated with their case. So thank you. Hope you support.
Good morning, Monica Hutchinson for Rise for Youth, and for all the reasons already given, we support this bill. Thank you.
Mr. Chair, there's no one else to speak in favor. If anyone online would like to speak in opposition, please raise your hand. Mr. Chair, there is one person online that would like to speak. Angie, please unmute and make sure your camera's on. And please unmute.
Okay, well, I would entertain or Senator Servell moves that we amend the bill to put a 10-year or put to toll the statute of limitations while the person during any period of time during which the person is incarcerated. Yeah, understand that?
Mr. Chair, I will say that I think Senator Williams-Graves' other bill that we will be hearing is what is trying to address that situation. And I see someone from OES, I think, coming up. I think there have been implementation problems with just doing a straight tolling of the statute of limitations. Okay. I think her other bill was seeking to attempt to address that, possibly.
Yes, ma'am.
Mr. Chairman, members of the committee, as I've been following the debate, it occurred to me that if the committee intends to amend this bill to toll the statute of limitations while the person is incarcerated, there may be an implementation issue there for courts and clerks in that we don't necessarily know the length of time that a person is actually incarcerated. We know the length of time for which a person was sentenced, and it could be told for that period of time, but we don't necessarily know the exact date that the person is released. That is not reported back to the court.
When a person's paroled, isn't it the court's experience, the Commonwealth's attorney and the clerk are notified that the person's, no?
Not that I know of, Mr. Chairman.
What I'm missing.
No, Mr. Chairman, I think that last point was potentially an important point. It's not just parole. It's once a person receives a sentence, then depending upon the earned credit that they obtain while they're serving that sentence, they could be out earlier, much earlier than the actual sentence. And I know of no tracking that takes place.
Mr. Chairman?
Senator
Carol Floyd. I guess speaking out loud to the committee. Once a person is released, their probationary period doesn't start until a person is released. So can't the payment due of the court costs and fines start when their probation starts, and it's 10 years from the date of that probation once they're released?
Mr. Chair, and Senator Carol Foy, if I may, I do believe that 564 may possibly address that. I am not aware, but is there a way to suspend conversation and hearing on 514 and take up 564 because it may, I'm sorry, 654, thank you. It may address your issue and then come back to 514. I'm sorry, 654. I apologize, 654. I'm not sure if there is a parliamentary way to suspend 514 to take up 654, because I believe that may alleviate some of your concern.
Well, yeah, I think that it's a related bill. They're not exactly alike, though. I would just soon get this figured out. What Senator Obenchain pointed out to me, and he's right, is that the statute of limitations is a plea in bar. It's something that if charges were brought or attempts were made to collect more than 10 years, the defendant could certainly raise that issue with the court. And
I'm sorry?
I think that we could I think that's something that the court could get figured out at the time of the collection.
Mr. Chairman, we're happy to work on the language of this. I think we would just need to ensure that there's some sort of notification mechanism in place, and happy to take a closer look at that language.
Okay, well, why don't we take this by for a day until Wednesday and try to come up with some language to make sure we've got that correct? And you've got one other bill, 654, you said?
Mm-hmm. We do.
Bill's been a motion to pass by, and that's seconded. All in favor say aye. Aye. Okay, the bill will be heard on Wednesday, and we'll get some language figured out by that time. Okay, 654.
Mr. Chair and members of the committee, Senate Bill 654, there are amendments.
Yes, Mr. Chair, and while they're being passed out and they'll be posted on LIS shortly, the amendments are at the beginning of line 155, strike that and insert for which. On line 155, after that such defendant strike is convicted of, and insert was sentenced on the same day. And on line 156, after agreement, insert as defined in section 19.2 354.1.
Okay, is there a motion on the amendments?
So moved.
Okay, motion and a second on the amendments. All in favor say aye. Aye. Opposed? Now, what's the import of the amendments?
Yes, Mr. Chair. They clarify that such deferred payment agreement may be for any other charge for which the defendant was sentenced on the same day, and then adds a technical edit that links the term deferred payment agreement to the definition, which is located in 19.2 354.1 for clarity.
Okay. Senator.
Thank you, Mr. Chair, members of the committee. This bill will give, Senate Bill 654 will give people with court debt a better opportunity to pay their debt prior to being hit with a 17% collection cost. This bill will amend Section 19.2-349 in two primary ways. It will change the timeline for outstanding debt to be sent to collections from 90 days to 180 days, bringing the timeline in par with when interest starts to occur. And the second thing that it will do is when someone is facing a period of incarceration, it will require the clerk's office to enter a due date on costs based on the maximum active period of incarceration of all charges in one sentencing event. The problem we are solving here is, as written, the Virginia Code permits unpaid court debt for criminal defendants to be sought while the problem that we're solving here is that, as written, the Virginia Code permits unpaid court debt for criminal defendants to be sent to collections 90 days after final judgment is issued if the defendant has not set up a payment plan. As soon as the debt is sent to collections, it incurs a 17% collection cost. So if someone is sentenced to a period of incarceration as part of their sentence, their debt can be sent to collections prior to their release, at a time when they are unable to pay. This is not a fair system, and it unnecessarily costs both the defendant and the state money. Amendments to the Virginia Code to give more time for people to pay their outstanding court debt changes the timeline from 90 days to 180 days, and for individuals who receive a period of incarceration as part of his or her sentence requires the clerk to enter a due date for when the court debt must be paid or a payment plan must be established as the release date on the greatest sentence. This will allow people recently released a greater opportunity to start paying their debt and avoid collections, saving money for the Commonwealth and the defendant. And we do have witnesses.
There are questions for Senator Williams-Graves. Okay, you've got witnesses. Do you want? We'll divide it up 5 and 5. Okay, everybody
Chairman.
that's in favor of this
I'm sorry.
bill. Senator Perry.
Yes, Mr. Chairman, I have a question, just a brief question for Senator Williams-Graves. Senator Williams-Graves, at the bottom of your bill, I think it's line 155, 156, it says the court shall enter into a deferred payment program. My question is related to certainly not everyone in the criminal justice system is indigent. And my concern about the word shall is I have had people who want to go ahead and pay off their court fees and court costs, regardless of whether they're going to be incarcerated or not. Their family has the money, they just want to take care of it and enter it off. The way I read that language is the court has to put them on a deferred payment program, and they don't have the option to go ahead and pay. And so I just had a question about that.
Mr. Chair and Senator Perry, I'm unaware of any instance where the court would refuse taking money for court costs and fines. And I agree with you that everyone is not indigent, but I do believe that sending someone to collections while they're incarcerated and unable to at least work is, I don't like the word unfair, but it's really unfair. And if they are able to pay them if they're able to pay or their family's able to pay, then by all means, it can. I think that putting a may in this instead of a shall will create a loophole. Some folks' stuff will get, dates will get entered in, and some folks' dates may not. This is just a directive of the court.
Mr. Chairman,
I'm sorry,
Senator Williams-Graves, I agree with you, and I agree with the sentiments of the bill, so please don't take it any other way. I just think you're running into the issue of maybe excess paperwork because the court's going to feel inclined to enter a deferred payment plan, right, and then the person can pay it off. I think that's accurate. My suggestion was going to be with the consent of the defendant, right?
Or for any indigent defendant.
Or, yeah, for an indigent defendant, or even just with their consent. Just let them consent. They can say, yeah, that's great, Judge, thank you so much. Or if not, then no need to go down that road. I think they still have 10 days to pay after the court enters its order without any penalty.
Mr. Chair, Senator Perry, if that is amenable to the great legal minds here, I would see that as a friendly amendment, and I would also see that as reasonable.
Mr. Chair?
Senator Carol Ford.
Yes, thank you, Mr. Chair. So it's my understanding that there is no prepayment penalty. So if a person wants to just pay off their court costs and fines, they can. It's the fact that it's just an automatic deferment or payment plan for people to take advantage of if they so choose. Some people don't know to ask for a deferment or a payment plan, and they don't, and then they're penalized when they don't pay or don't pay on time. So I think a lot of jurisdictions have automatic, payment plans that they just put everyone on. However, if you do pay and pay in full, then there is no penalty.
And Mr. Chair, Senator Carol Foy, I don't think that changes anything that I just said. I think if anything, this would open up the discussion to allow the person to say, hey, I'm going to go ahead and pay it now and just save the court some paperwork. Like I said, I support the bill. I support the contents of the bill. Just trying to clarify and clean up that the court doesn't have to go through those steps if the person is going to go ahead and pay right then and there. And I agree there's no prepayment penalty. But I think if you have the consent of the defendant, you can ask them, do you want to do this? Do you not want to do this? This is what you're inclined to do. If they want to, of course, they can and should say that, and their counsel should advise them of such. But if not, then it just saves the court a step.
Again, Mr. Chair, members of the committee, Senator Perry, Senator Carol Foy, I agree, appreciate the input. I don't have a problem with the amendment with the consent of the defendant.
Chairman, I believe it would go down on line 155. It says, well, I believe, I take it back with the amendments. I'm not sure exactly what line it is. I don't think my system has been updated, but it says, for any defendant sentenced to an active term of incarceration in order to pay any fine, cost, forfeiture, or penalty related to the charge that such defendant is incarcerated for, any other charge that such defendant is convicted of, the court shall enter such defendant into a deferred payment agreement. Where the line where it says the court shall enter such defendant, I think what you can say is
the court
shall advise such defendant and with the consent of the defendant enter the defendant into such payment plan, into such deferred payment agreement, etc.
Mr. Chairman?
Senator Carol Ford.
Yes, Mr. Chairman, I guess the thing that I take pause with is that then this bill becomes nothing more than what the courts can already do. So at any time, a defendant can ask to be put on a payment plan. So when you change the shall to a may, you're basically giving the court authority that they already have. So this is a nothing burger bill if you change the language. So I just want to put that out there. And if counsel can correct me if I'm incorrect.
I'm actually not suggesting removing the word shall, Mr. Chairman. I think shall with the consent of the defendant, right? That's it.
I think that is what she said. I mean, I agree that the court has discretion to do this already, but we're ordering with that her language. All you're saying is the defendant has to consent to the. They're going to be. They have doesn't remove the court's doesn't remove the mandatory nature.
Mr. Chair, I understand, but that's already the process. The defendant requests the payment plan, and then the court enters them in. That's how that works.
Okay. What's the pleasure of the committee with respect to
Mr.
the
Chair, can we get an opinion from
counsel?
Yes.
Mr. Chair, I think if the committee wants to add with the consent of the defendant, we can add that. I was just looking, I think it's already required that they let the defendant know that they have the option to enter into a deferred payment agreement. So I don't think we need to add the language about advising them. I'm just trying to think through, and perhaps OES may be able to clarify, but just I think the intent of the bill is to require the court to enter every defendant into a deferred payment agreement in order to sort of address the issue that the committee was discussing earlier about tolling the statute of limitations for collection. So requiring they enter into this deferred payment agreement so that there's a deferred date that the payments will become due. So I'm just trying to think through whether requiring consent of defendants would
Senator Boysko's
hold that up.
Got something.
Mr. Chair, Senator Williams-Graves, I carried this bill last year, and I think that we're losing the purpose of the bill, which is to line up the date that the court sends to collections and the date that the individual is required to start paying so that they sync up, so you're not accruing additional fees and debt before you're even being asked to pay the fines and fees. And I think we've lost the purpose of the bill in the conversation that we're having up here. So I'd just like to reframe it for the body.
So, Mr. Chair, members of the committee.
Senator Williams-Graves.
My request would then be to have the committee vote and pass the bill as presented with the original set of amendments that were agreed to. And we do have testimony.
Senator Boysko's got something else. Have we already taken testimony on this bill? We have 5 minutes on each side.
If there's anyone online that would like to speak in favor
Okay,
of the
come
bill,
on.
please raise
Come
your
on.
hand.
Time's a wasting. Let's go.
Thank you, Mr. Chairman, members of the committee. Emily King with the Commonwealth Institute. We support this legislation. Thank you.
Thank you, ma'am.
Hello, members of the committee, Mr. Chair. Maisie Osteen from the Legal Aid Justice Center, and we really thank the patron for bringing this bill, and also to OES for working on the language. I do really appreciate Senator Perry's idea about the consent. However, we discussed it with OES, and there's no issue for somebody paying ahead of time, and in fact, you're incentivized if you are going to be incarcerated to pay in full, because otherwise parts of the meager wages you do have are sent to fines and fees. So you really are incentivized to pay as fast as you can still. But this timeline will help people make sure that they can get out, get on their feet, and then start paying, as well as make it a lot easier for clerks and other people who are navigating the system to know that interest and collections start at the same time. Thank you. Thank you.
Okay, thank you.
Hello again, Mr. Chair, Dominic Martin of Virginia Majority, again, for that purpose of making sure that we believe this is a kind of policy decision to make sure that people can come back, take care of the things that they absolutely need to, and make sure that they do not recidivate and get themselves established and stable. And so for those reasons, we hope you support the bill.
Monica Hutchinson, Rise for Youth, and we support this bill. Thank you.
Taia Mallory with the Virginia NAACP. We support the bill for all the reasons the Senator presented this morning. We thank you.
Okay, thank you, ma'am.
Mr. Chair, there's one person online that would like to speak. Taj, please unmute and make sure your camera's on.
Good morning, Mr. Chair, members of the committee. Thank you. Taj Mayenhaft with the Humanization Project and member of the steering committee of the New River Valley Reentry Council. We support this bill strongly for all the reasons aforementioned, also because we are seeing these collections notices hindering housing opportunities for people who are already hindered coming back into the community. Having that on your record makes it very difficult. We have a housing crisis in reentry right now. Thank you very much.
Thank you, sir. Is there anybody else? Okay, the other side, are there other views?
If anyone online would like to speak in favor, in opposition to the bill, please raise your hand.
Anyone in the audience who would like to speak in opposition? Okay, the bill's before the committee.
Move to report.
Second. But it has to go to finance.
And refer to finance.
Second. Bill's been moved to report and be referred to finance with a second. Are there other motions? Please open the roll.
Ayes 9, no 6.
Okay, the bill goes to finance. Now we are down to member bills.
Thank you, Mr. Chair, members of the committee.
Senator Diggs has a bill? Okay, I apologize. Senator Diggs. Okay, 583 is your bill. Is that right?
Yes, sir. Thank you, Mr. Chairman. So what this bill does is exempt highway rest areas from the state agency gun ban. So imagine yourself leaving your home, you're headed down the highway, and your child, your wife, either becomes ill, you have to go to the bathroom, or you've been on a long journey and you must feel you must pull over to take a rest. When you left that morning, you were not going to the DMV, you were not going to Capitol Square, you were not going to any other state agency with the intent to travel to that. You were merely going on a trip, and you were lawfully in possession of a firearm, but now you have to unintentionally stop at a rest area. And as you stop at that rest area, you have now become subject to a firearms ban, where you become a criminal at this point, subject to a penalty of up to 1 year in jail. And please remember, you had no intent whatsoever to ever end up at a rest area as you took upon your journey today. And there are, rest areas can be dangerous places. There were 66 crimes in 2020, 57 in 21, and 82 in 2022. And those crimes included aggravated assault, manslaughter, kidnapping, abduction, rape, and sodomy. So not only do you give up the right to protect yourself, you now become a criminal yourself. And as we heard earlier today, there was great reluctance to punish criminals who intentionally use guns in a second offense, yet we are now making criminals out of law-abiding citizens who just happen to need to take a break or go to the bathroom. And so this is one of the most common sense exemptions that you can think of. There is no intent whatsoever. You're just traveling down the highway, and you land up that you're now subject to a year in jail because you had to go to the bathroom. So again, this is just a common sense exception to a ban of firearms on state property.
Okay, I think we understand the bill. This just allows you to carry a concealed weapon into a rest area. Is that correct?
That's correct.
Okay, if you've got a concealed carry permit, you can carry the weapon into a rest area.
I'm sorry, Mr. Chairman?
You've got a concealed carry permit.
In this case, you would not necessarily have to have a...
You wouldn't have to have a permit. You can still carry a weapon into a rest area.
Yes, sir.
Okay, are there questions for Senator Diggs? Okay, are there people that are for it? We'll give 5 minutes on either side.
If there's anyone online that would like to speak in favor of the bill, please raise your hand.
Mr. Van Cleve.
Yeah, Philip Van Cleve, VCDL. This
rest areas are certainly not a sensitive government area. This is not something that government would shut down if there was an attack on it or anything. This is just a place where citizens go. I frequently stop at rest stops, and there's rarely a state police officer around. There's a slot for them, but they're rarely there. They've got more important things to do than sit in rest areas all night. So we would strongly support this bill. Thank you very much.
Okay, thank you, sir. Next.
Morning, Mr. Chairman, members of this committee. Taylor McKee with the National Rifle Association. We also support this bill. We think it allows law-abiding citizens to protect themselves and their family.
Okay, thank you, sir. Next.
Good morning, Mr. Chairman. Patricia Webb, Virginia Citizens Defense League, and also speaking as somebody that drives on our highways. I would ask the committee to look at this not as a gun bill, but as a highway safety bill. People drive long distances for their jobs, for vacations, whatever, and if they become drowsy, the safe place in Virginia to pull over, rest your eyes for a little bit, and recuperate is a highway rest area. So if you're carrying a gun lawfully, because the criminals don't care if it's against the law to go into the rest area with a gun, but if you're carrying a gun lawfully, you've taken away that option for safety. Also consider there are truck drivers and there are others that carry very valuable cargo, and they need to have a means to protect themselves from those who would take that cargo. And you're denying them the ability to stop at our beautiful rest areas in our beautiful state legally. So I urge you to look at this as a highway safety bill and not as a gun bill, and see favorably and pass the bill. And I thank the senator for bringing it.
Thank you, ma'am. Are there others? Are there people online who would like to speak?
Mr. Chair, there is no one online to speak in favor
Okay,
at this
are there
time.
people that have another point of view?
If there's anyone online that would like to speak in opposition of the bill, please raise your hand.
Yes, ma'am.
Hi, good morning. My name is Lindsay Lang. I'm here representing Moms Demand Action, and we oppose this bill. Thank you.
Thank you, ma'am. Yes, sir.
My name is Keith Conway. I'm a gun safety advocate. I'm not a hypocrite. And this law gives people concealed and carry in a place that they would ordinarily not get concealed and carry. It also, if you read this bill, you're allowed to have explosive material in a building owned and issued by the Commonwealth. I think those people should be arrested if they bring explosive material into these buildings. Thank you very much.
Mr. Chairman, can I ask the witness
Senator
question?
Stanley's got a question.
I'm
He
ready.
wants to debate.
Good. Are you aware that over 40% of crimes that are committed against truck drivers, the people that carry our commerce, are violent crimes and occur at rest stops and usually when they're stationary?
Are you aware that in Virginia, no, I'm not, but are you aware that in Virginia, a man was going to the bathroom and he was robbed in one of these places and shot by guys with guns?
I think, Mr. Chairman, he's just proved my point.
We aren't having a debate, and Senator Stanley, we aren't having a debate either way. Questions are all right, but let's not.
Mr. Chairman, final question.
Senator Stanley.
And I would ask the witness, understanding that these men and women that drive these overland trucks to make sure that we have the necessities of life, if they come into a rest stop with this bill and that bans, or that we ban the use of or the possession of firearms, are we not leaving them without any protection whatsoever as they sit there and suffer from crimes such as theft, rape, and robbery, as it's stated here in the statistics on violent crime against our truckers?
I don't need a gun to go to the bathroom. Is that a complex answer?
I don't need a gun to go to the bathroom either, young man, but...
Well, neither do they.
But we're talking about, Mr. Chairman...
Everything has to go through the chair. We're just to answer the questions, no debate, okay?
I don't think that they need those weapons to go to a restroom. Is that an answer?
Thank you so much. Yes.
Okay.
Next.
Good morning, Mr. Chairman, members of the committee. My name is Lori Haas. We understand that there is certainly some consideration that needs to be given to persons traveling across the Commonwealth. This prohibition applies to state-owned restrooms and rest areas. It does not apply to commercial convenience stores and other rest areas that are privately owned that may or may not have a regulation. This only applies to state-owned property. Persons are and can and readily can make themselves find places to stop that have restrooms, that have a place to park their vehicle. You know, traveling to and from Virginia Tech, when I was enrolled at school, my father often said, go to a truck stop. They're the safest place in the Commonwealth if you're traveling alone and you need to go there. These are just the state-owned properties. So it does not prohibit someone from going somewhere else for whatever break they may or may not need.
Senator Jordan's in the 21st century, and I'm still in about the 19th century. She's appropriately asked for the floor electronically, and I apologize for not recognizing her earlier. Senator Jordan.
Thank you, Mr. Chair. Would this be the appropriate time to speak to the bill?
Excuse me?
Would this be the appropriate time to speak to the bill?
Well, if you want to speak to the bill, let's wait till everybody has a chance to speak.
Yes, sir, Mr. Chair.
Good
Yes,
morning,
ma'am.
Mr. Chair. I'll be brief. Lydia Ballard with Brady, and like Lori Haas said, we understand the intent behind this bill, would like to see it worked to come to more consensus around things like safe storage and some guardrails to ensure that folks, no matter if they want to carry a gun or not, are safe at these rest stops. Thank you.
Okay, thank
Mr.
you.
Chairman.
Are there other? Senator Stanley's got a
I'd
question.
like to ask you a question. Do you believe that by prohibiting guns from being allowed to be carried onto rest stops, that will stop the criminal when he sees the sign? He'll turn around and not go to that rest stop because the sign says no guns allowed?
Mr. Chair, I understand the question. I would also be eager to present the data that proves that more good guys with guns do not stop bad guys with guns, which I know is a commonly held belief, but is something that statistically has not been proven. So I don't know that more guns at these rest stops would keep folks safer.
Mr. Chairman.
Senator Stanley's got a question.
My question is this. Do you believe that by prohibiting the possession of firearms on a public state-owned place such as a rest stop then stops the bad guy with a gun who then says, geez, I was going to go to that rest stop and rob and shoot somebody, but now I'm not because they don't allow the firearm that I'm going to use to kill him?
Mr. Chair, I can't pretend to understand the motives of criminals, and I'm not sure whether they would be deterred or not when they see that signage.
Of course you can't. Thank you. Senator, are there others? who wish to
Mr.
speak?
Chair.
Mr. Chair.
You're next. Senator Jordan.
Yeah, Mr. Chair, if I could ask a question of the witness. I live in a very, very rural district. I travel, my district is about the size of the state of Delaware, and I travel frequently on rural roads, and oftentimes the only place I have to stop is a rest stop, and frequently I'm by myself going to and from places. What would you suggest I use to protect myself if I am not allowed to exercise my Second Amendment right?
That's right.
Mr. Chair, I, as someone who does not carry a firearm and I don't desire to, I don't know that it would make me feel safer. I don't know that I could tell you what to do to protect yourself in that case, but I do know that our stance is that more firearms would not make that a safer place for you.
Mr. Chair,
Senator Jordan.
follow-up question. Could you answer the question? What would you suggest I use to make myself feel safe if I'm not allowed to exercise my Second Amendment right?
Mr. Chair, I often ride my bike on very rural roads. I'm alone as a woman also in situations you're describing. I carry pepper spray on my bike. That makes me feel safe. I'm not sure that it would make you feel safe just because we are different.
Thank you very much. Follow-up question, Mr. Chair?
Senator Perry, Senator Jordan.
Thank you. I think this is a question maybe for council. Wasn't there a bill a year or two ago that also banned the use of pepper spray and stun guns on buildings owned by the Commonwealth? Am I correct or incorrect?
You still want to speak?
Mr. Chair, Senator Jordan, we'd have to look it up. We're not sure off the top of our
Mr.
head.
Chairman, Senator Jordan, we don't know. We think so, maybe, but it may have been the original version of the Capitol Square bill.
Correct,
But
and I
we
believe
can't-
it in.
We can't say with certainty
Yeah.
right now.
So, Mr. Chair, if I can speak to the bill at the appropriate time.
But, Mr.
Okay,
Chair, can
Senator Jordan's got the floor.
Mr. Chair,
Thank
can
you,
I ask
Mr.
a
Chair.
question before we start speaking to the bill?
Senator Perry's got a question. Senator Boysko wants to speak. Senator Jordan wants to speak. I mean, what is it with everybody?
The ladies have a lot
Mr.
to
Chair,
say.
I would say ladies have a lot of questions.
The ladies have a lot of questions. And Senator Stanley's got a lot of questions, too. Senator Perry.
Yes, thank you, Mr. Chairman. It's not a question for you, ma'am. Thank you. This is a question for council or for Senator Diggs. My question is, the way that I read this bill, if I look up at subsection B, the places where it's unlawful for a person to carry, I think that the highway rest area would be covered by probably B, little I, the three little I's, any building owned or leased by the Commonwealth or any agency thereof. And so I guess my question is for Senator Diggs or for council is, if I pull up into a rest area and park my car and have a firearm in my vehicle, and I get out of the vehicle and go inside the rest stop to go to the bathroom, I don't believe I've actually violated the provisions of this statute. I think that I can leave my firearm in my car, the one that I've traveled around the country with, so that people can pull off and rest their eyes and other things like that I agree are important and that we want to encourage people to do. But that all it really prohibits is me going into the building itself with my firearm. Is that correct?
Mr. Chairman, Senator Perry is correct.
Thank you, Mr. Chair. So what I would say is I don't think we still have a clear answer on whether stun guns and pepper spray and things of that nature are banned. Do we not have a clear answer? On Commonwealth owned
No,
property?
they are not banned, Mr. Chairman.
Okay. So as of now, so I would hope that we will not see a bill, I would say, in the near future if we're going to, go in the direction that I see this bill may go. But I want to thank the patron for bringing the bill, but also we have an opportunity, I think, here, to respect law-abiding gun owners without infringing upon their rights first. Second, this may mean that I may not utilize a state rest stop in the future if I don't feel safe, just stopping to use a restroom when I'm by myself. And I don't think this bill is anywhere near unreasonable. So that's just my take on this bill. Thank you, Mr.
Stewart's got an electronic request.
Thank you, Mr. Chairman. Speaking to the bill, if I may.
You may.
I just want to commend Senator Diggs. He's come in, he's doing a really good job, and he's presenting some very common sense bills. And unfortunately, I think I have a sense of where this bill is going in front of this committee, and it's disheartening. He brought a bill the other day to keep child molesters out of state parks, and the bill was killed. And I think this committee is going to kill a bill today that essentially says you're a criminal if you stop at a rest area with your shotgun in the back of your truck after you've been dove hunting.
That's not what it says. That's not what this bill says. The law right now says you can carry a gun in your car and park on the lot. This says you can't carry it. This is a bill to give him the right to take a gun in the building, in the rest area. But there's nothing about this, nothing in the law right now that prevents you from having a weapon in the car.
Second.
Okay, we got a motion to PBI, and that's been seconded. Are there other motions? Please open.
Substitute motion to report.
To report. Substitute motion to report. Okay, substitute motion takes precedence. The motion is to report. Open the roll.
Ayes 6, noes 9.
Ayes 6, noes 9. Do you want to can we reverse the roll on the PBI? We
Need a motion to reconsider.
So moved.
Motion to reconsider?
Okay, we'll go back to the original motion then.
It's a motion to reconsider.
No, it's not. Just go to the original motion. Original motion was the PBI. Open the roll, please. Okay,
Ayes
thank you.
9, no 6.
Thank you, Senator Diggs. Senator Boysko, we're
Thank you,
in
Mr. Chairman.
committee bills now. So Senator Boysko's got two bills. 357 and 368. Do you want to take them in numerical order, or?
Mr. Chair, let's start with 368.
Okay.
The storage of firearms in a residence where a minor or persons prohibited from carrying a firearm are present.
368, please turn your attention, Senator Boysko.
Thank you, Mr. Chairman. This is a bill that we heard last year, only weeks after a child took a handgun into his school. A 6-year-old got it from his mom that was not properly stored, shot his teacher in the stomach, and she is still dealing with the repercussions of that today. This is a bill that would require any person who possesses a firearm in a residence to store that firearm safely whenever they know that there's a minor or another person who is prohibited from accessing a firearm present. It requires that firearm dealers post a notice stating that a firearm storage requirement and the penalty for improperly storing the firearm sets it as a Class 4 misdemeanor, which is not prison time, but is a financial penalty. It also exempts any person who, in lawful possession who carries a firearm on or about their person in the household, and there is an exemption for storing an antique firearm. This data is very clear. Approximately 1 in 3 U.S. households contains at least one firearm. In those households with children, 1 in 5 gun owners stores at least one of their firearms loaded and unlocked, whereby any minor could easily gain access. The data shows that 76% of school shootings are committed with guns that they got from home. 80% of firearm suicide by minors involve a firearm belonging to a family member. 76% of unintentional shootings of children were committed with unsecured guns from home, most often stored in a nightstand or another sleeping area. From 2003 to 2021, 1,262 children were killed in fatal unintentional firearm injury, with approximately half caused by another person. There should be a clear standard to penalize those who do not safely store their weapons. There needs to be accountability for those who leave firearms unsecured. These are preventable deaths and injuries. And I urge you to adopt this bill. There are very affordable storage biometric units, and we just passed a tax credit last year. And I'm getting a thumbs up from one of my good friends. Yeah, absolutely. I think that's a good thing, whatever we can do to encourage people.
I understand from staff we have a couple of technical amendments.
We do, Mr. Chairman. On line 14, continuing to line 15, strike the words "under 18 years of age," because that necessarily is a minor, someone who is under 18. And then on line 18, after the word minor, insert "or prohibited person."
Okay, do I have a motion on those amendments? All in favor, say aye.
Aye.
Any opposed? Okay, the bill's amended. I guess there are people here that want to speak to this, so there are 5 minutes on each side. Yes, Senator Stewart, I apologize.
Thank you. Probably to Mr. Benjamin. So would this be an additional charge to reckless endangerment or reckless handling, or would it replace that? And there may be others.
Mr. Chairman, Senator Stewart, this would be an additional charge.
So, Mr. Chairman,
Senator Stewart.
so essentially this is an effort to stack charges against people, or what do we call it, piling on charges, Mr. Benjamin?
Mr. Chairman, Senator Stewart, that's not for me to say what the motivation is, but it would permit what we call stacking of charges in the right situation.
And, Mr. Chairman, I apologize. I would never question my friend's motive. I didn't mean to say it that way, but it has the end result of stacking or piling on charges.
Senator Stewart, your motives are pure.
Thank you.
Mr. Chair.
But one who's Senator, or Delegate Senator No, I want to ask, one who is guilty of reckless handling of a firearm wouldn't necessarily be guilty of this offense, would they?
Mr. Chairman, you are correct.
So one could be guilty of this offense and not be guilty of reckless handling of a firearm.
That's correct, Mr. Chairman.
And Mr. Chairman, I'd just add, it is difficult to find the reckless endangerment charge. We have examples where there was a firearm left out and they were not able to prosecute for that charge. This is a lower threshold, and we believe that it would be more helpful to keep guns safely stored and save lives.
Okay, thank you. 5 minutes on each side. I'd like for the people that are for the bill to line up. Come on, give
If
us your
there's
best
anyone
shot.
online that would like to speak in favor of the bill, please raise your hand.
Yes, ma'am.
Good morning, Mr. Chair. I'm Dr. Barbara Boardman. I'm a pediatrician, and I'm here today speaking for the Virginia chapter of the American Academy of Pediatrics. You may wonder, why do pediatricians care about this? The answer is simple. We are the ones who see patients who die from community violence, from family violence, from suicide, and from unintentional injuries by firearm. Firearm injury and death is preventable, and we know from research that effective gun legislation can mean the difference between life and death for our young patients. As healthcare providers to children, this is a public health issue and something that would help protect many of our minor children. The child and teen firearm death rate has increased by 129% over the last decade. Also alarming, over 80% of adolescent firearm suicides involve a gun belonging to a family member. We have to say that now the leading cause of death for children is firearms. Evidence suggests that teens often act impulsively. We can reduce young people's easy access to loaded and unsecured firearms. We can save lives. Responsible gun owners should limit developmentally impulsive minors from having access to dangerous firearms. Thank you for the opportunity to speak in favor of this bill.
Good morning, Mr. Chairman, members of the committee. My name is Lori Haas. We wholeheartedly support this bill. Firearms are the leading cause of death for children in the Commonwealth and across this country. I'd like to point out that in times past, many of you aren't old enough to remember this, but we did not require child safety seats, infant and children and toddlers to be in child safety seats. We didn't require it. They weren't being used enough. And thankfully, this body and most every state across the country implemented child safety laws to require that parents put their children in a child safety seat. This is following a very typical path. If parents are not locking up their firearms when children are present in the home, then they must be required to. Laws work, laws matter. You are a legislative body, you're making laws. Let's protect the children of the Commonwealth by requiring gun owners to lock up their firearms when children are present. Thank you.
Okay, thank you, ma'am. Next.
Hello, Chairman and members of the committee. My name is Mary Ann Resson, and I'm a volunteer with Moms Demand Action. We support this bill, and I would just like to address that this bill would support more children, especially ones who may commit an irrevocable act. And a lot of times this is impulsive in their nature because of their age. Thank you.
Thank you, ma'am. Next.
Good morning, Mr. Chairman. Liddy Ballard from Brady. We strongly support this bill. Thank you.
Thank you, ma'am. Next.
Talia Mallory, Virginia NAACP. We support the bill.
Thank you. Yes.
Hi, Kristen Kanaski, Assistant County Attorney with Fairfax County, and we support this bill.
Okay. Thank you, ma'am. Next.
Monica Hutchinson, Rise for Youth, and we support this bill. Thank you.
Thank you very much.
Mr. Chair, there's one person online that would like to speak. Okay. Virginia, please unmute and make sure your camera's on.
Thank you. I'm Virginia Rosnack with the Charlottesville Coalition for Gun Violence Prevention and the Charlottesville Center for Peace and Justice for all the wonderful reasons given. We strongly support this bill. Thank you.
Okay, thank you. Yes, sir.
Chairman, Andrew Goddard, Virginia Centre for Public Safety. We support the bill for all the reasons given. But I would like to say that I don't want to come here and talk about evidence-based actions which will reduce gun violence and talk against evidence-based things which will not reduce gun violence and have my motives impugned by members of your committee. Thank you.
Thank you, Senator Obenshain. You stirred it up again. Come on.
Just a quick question. I'm curious if someone were to offer an amendment to make this a Class 5 felony as a result, if someone dies as a result of failure to secure a firearm, would you support that?
I would like to see a tiered thing where if no harm was done, there was a lower penalty and an increasing penalty for increasing harm. Yes, I would probably support that.
Okay. Thank you.
Okay, thank you very much. Now we're turning it back over to Senator Serval.
Where are we?
Mr. Chair, we're in the safe storage bill that we heard last year and passed through this committee.
Okay, let's go with opposition. 5 minutes. Did we set a timer? Support?
If there's anyone online that would like to speak in opposition, please raise your hand.
Mr. Chair, Philip Van Cleve, VCDL. One thing I do want to set straight, we keep hearing that firearms are the leading cause of death of children. Not true unless you think an 18 and a 19-year-old are children. They purposely throw that stat in, don't mention it, to throw in the violence, gang violence and stuff that brings in the higher firearms deaths. One size does not fit all. Now, some parents are very good at educating their children about gun safety. They teach them at a young age how to safely handle a gun. There have been many cases where 15, 16, 17-year-olds have used a gun to stop a home invasion or some severe violence against a parent. So really, parental discretion needs to be allowed here because, again, not everybody has the same training, the same situation in the House. So I would hope you would oppose the bill. Thank you.
Thank you, Mr. Van Cleve. Next.
Good morning, Mr. Chair, members of the committee. I would like to point out a couple of problems with this bill. One, it requires a loaded firearm be stored in a biometric storage device. Not all biometric devices are created equal. They're not always reliable. If your hand is wet, you can't open it. If you held your loved one who is bleeding because someone attacked you and you have blood on your hands, you can't open the safe to get the gun out to defend yourself. Not everybody can afford a biometric safe. And this takes away parental rights. So me, I owned and ran a convenience store for over 30 years. People thought we had large sums of cash at home. A woman that worked for me had a convenience store prior to working for me, and she was robbed in her home in a rural area at gunpoint. And so it is a very distinct and real possibility that my kids, when they were at the house next to my store, somebody could have broken into that house. And when I felt they were old enough and responsible enough, I gave them the combination to the safe, and I would do it again. This also requires that dealers post a notice. Who is paying for those notices? How are they to be posted? It doesn't say. And we hear a lot about the leading cause of death among children. The study being cited that shows firearms being the leading cause of death among children goes up to the age of 19 and includes gang violence. The numbers are way skewed. If you take out 18 and 19-year-olds who are considered adults by our legal system, then the numbers drop exponentially, and car accidents are actually the leading cause of death, and firearm deaths are way, way down the list. They don't even make the top 10. So I urge you to oppose this bill. Thank you. It's a matter of safety.
Thank you. You got minute
Mr. Chairman,
35.
Good morning, members of this committee. Taylor McKee with the National Rifle Association. We oppose this bill. While the NRA advocates for safe storage and safe responsibility, we don't think it should be mandated. This could be cost prohibitive to some Virginians and be priced out of being able to exercise their Second Amendment rights. Also, as we stated earlier, the senator did, there are already bills or statutes on the books that restrict providing firearms to prohibited persons and dangerous juvenile delinquents. And for those reasons, we oppose this bill. Thank you, sir.
Mr. Chair, there's one person online that would like to speak. Anne, please unmute and make sure your camera's on.
Okay. MJ, you reset the timer there?
Yeah, I just briefly.
What was it at? Hold on, ma'am. What was it? We were at like 1 minute or something, weren't we? Yeah, so we'll set it to 1 minute. Go ahead, ma'am.
It won't take me 1 minute. Briefly, what I want to say is that a person that comes in the middle of the night to do harm to myself or my family has the element of surprise at their advantage if I'm asleep. I'm not going to have time to run around and unlock a safe and find my magazine and insert it and load it and then pull the trigger. Me or my family could already have been in harm's way, and I lose the right to defend myself with this bill. I think most people that have weapons, they should be responsible for their weapons and responsible for their children. I oppose this bill. It restricts my right to self-defense. Thank you.
Thank you. I think that's it. Senator Boysko, final word.
Just a year ago, we saw a 6-year-old first grader who brought his mom's gun into the school and shot his teacher in the stomach. This bill passed with bipartisan support through the Senate last year. I hope that my colleagues will do the same again this year. This will be a life-saving measure. It doesn't take anybody's Second Amendment rights away from them. It's a common-sense solution.
Thank you, Senator. Any further discussion with the committee? Yes, Senator Stewart.
Senator Boysko, if I read this correctly, and if I have a weapon that is loaded, but it's secured in one of the big gun safes with the combination lock, I would still be guilty of a Class 4 misdemeanor. Is that correct, the way the bill reads?
Mr. Chair, the bill reads that you need to take your ammunition and store it separately unless you have a biometric lock.
Mr. Chairman.
Senator Stewart.
So I've got to have a biometric safe instead of one of those big gun safes or other mechanisms. Is that correct?
Mr. Chair, my understanding is that if you want to keep your gun loaded in your house where children or people who are prohibited could easily access them, the requirement under this bill would be that you either put it in a biometric safe, which you can just put your thumb on, or you separate the two and lock them up.
Mr. Chairman.
Senator Stewart.
And this is an honest question, but why isn't a traditional gun safe, and there are, I mean, I've owned guns all my lives, and I believe your intent is a good thing. I never let my children have access to my guns or ammunition as they were growing up, thank goodness. But why do we need to go to a biometric safe as opposed to other methods of safe storage? That's what I'm getting at. What's the point?
Certainly. Thank you, Senator, Mr. Chairman, Senator Stewart. This is really fast access. If you need to have your gun at your hand quickly and it's not on your person, a biometric safe will immediately allow you access into your gun. You can put it in your bedside table, put your thumb on it, it will unlock. You can get it and use it immediately if there is an emergency that you need.
Thank you.
Okay, any other questions? Senator Boysko.
Mr. Chair.
Senator Subramanian. And Stanley. Okay.
Mr. Chair, I'll just make 2 points. I thank the patron for bringing the bill. One, I heard a lot about costs, but we just passed a tax credit that pretty much, I was just Googling, covers the cost of a biometric safe. And so I don't really think the cost should be the reason not to support this bill. And then we've already seen several instances the patron mentioned of really bad results from not locking up, especially of kids in the house. So I would support this bill.
Thank you. Senator Stanley.
Hold on.
Oh, is he? Okay, Mr. Benjamin,
Mr. Chairman, Senator
question,
Stewart raises a good point, and it may be an unintentional omission. You see on line 17 the provision under the bill that a firearm may be stored loaded in a biometric safe, but there is no prohibition against storing a firearm loaded in a locked container, as the bill now reads. And it may be that an amendment would be desired by the patron, but currently there's certainly not a prohibition against storing a loaded firearm simply in a locked container. I don't see that prohibition in the bill.
Okay, Senator Stewart, are you? Okay, got it. Got it. Following Mr. Jefferson's rule. Senator Stanley.
Speak to bill, Mr. Chairman.
Go ahead.
Mr. Chairman, I have the utmost respect for the patron of this bill, and I understand what she's trying to do, and I respect that as well. My concern is, as a criminal defense attorney, the enforcement provisions, because this seems like no police officer or law enforcement would know that you're not locking up your firearm until something happens. So it would be a backward-looking bill, and then you would be charged with a Class 4 misdemeanor. And then I'm reminded, and I just went back to check, that when I looked up the very case that the patron's talking about, Ms. Taylor, who pleaded guilty to charges, she was the mother of the Virginia 6-year-old who shot his first grade teacher in class. She was sentenced to 21 months in prison for federal felony offenses. Those 2 felony charges were the unlawful use of a controlled substance while possessing a firearm and making a false statement while purchasing the firearm, which in my mind, without further reading, says that that person did not have the ability to possess or purchase a firearm at the time that she purchased it, and filled out the form incorrectly and lied about whether she was eligible to even purchase a firearm. So that, in my mind, presents the question where the laws that we have already on the books are not enforced properly, or that people go around them, that no guns on the premises laws are not going to stop the criminal. Then I went down to see, and I said, well, these are federal charges, Mr. Chairman, and I wanted to understand then. So the feds took basically the fact that the defendant was in possession of a firearm while on a controlled substance, using drugs, and possessing a firearm is illegal, state and federal. Lying on the form is both state and federal. So I was wondering if the state prosecuted Ms. Taylor. And then I found this, where Ms. Taylor has also now pleaded guilty to state charges of felony child neglect. That charge has a maximum sentence of 5 years. But prosecutors have said they will not seek a punishment beyond the sentencing guidelines of 6 months. So what we're trying to do here in a Class 4 misdemeanor setting, I think, is taken care of when these situations arise with both federal charges and state charges. And I think this is some redundancy, and some redundancy is okay. But I think in this manner, it's unenforceable, and there are more serious charges that can land the parent or the adult or guardian in jail for failing to secure their firearms in their homes that result in the harm to others. And therefore, respectfully, I'll be voting against the bill. But thank you.
Thank you, Senator. Any other comments, questions, motions? MJC, you go to finance? Nope. Okay. Clerk will open the roll.
Ayes 9, no 6.
Right. Thank you, Senator Boyce. I think you have one more, and then we're going to get to
Yes,
Senator Bagby, right?
SB 357.
Okay, I think you have a substitute on this, right?
Yes, sir.
Okay, Senator Bagby moves, Senator Subramanian seconds to adopt the substitute. All those in favor say aye. Aye. Anybody opposed? No. Okay, the substitute's before the committee. Senator Boysko, why don't you explain to us this much narrowed bill over the one you introduced?
Yep, absolutely. As I introduced the original bill, it would say that if an officer comes to a home of a person who is in crisis, whose behaviors are consistent with mental illness, intellectual disability, developmental disability, such as autism spectrum, that there would be no arrest. After significant discussion and back and forth with the sheriffs and the police department, as well as other colleagues, we have changed it to an affirmative defense to the prosecution of an individual for assault and battery of a law enforcement officer. If at the time of the assault or assault and battery of a law enforcement, the officer was responding to a request for service.
Senator Boysko, hold on one second. We have a question down here. I got 357. Mine's 357, Senator Peak. It says assault and 18.
You got a 357?
The goal was just to keep you in the dark.
Yeah, we don't want you to have the real bill.
I got the right one.
And these last two are 356.
Okay. All right, Senator Boysko, I think we're organized now.
Okay, thank
Keep
you
on
so
going.
much, Mr. Chair. Sorry for the inconvenience, Senator Peak. So this changes the original bill, and we've had this bill many, many years. Mr. Chair, you and I have worked on this, I think, since 2020 in some form or fashion. But the idea is that we have a number of individuals with autism on the spectrum, developmental disability, and people with mental health crises that are being subject to a mandatory minimum and sent to prison for certain amounts of time, where they might have thrown an onion ring, they might have spit, they might not have been able to control their movements and slapped an officer. This is a bill that we've heard a number of times. The families of these individuals have repeatedly asked us to address this unique situation for them so that they are not incarcerated. This takes away the judge's and jury's ability to fashion an appropriate sentence based on facts of the specific case and person, including their consideration of their disability. It can lead to traumatic lifelong consequences for those individuals with autism, intellectual disability, or serious mental illness. And while we're working towards a system that we can call for a mental health response unit, we still don't have that fully in place. We need to be able to call the law enforcement officer to ask for help without criminalizing the disability. I know that there are a number of people here. If under the current law, the simple assault and battery, which again could be as much as spilling water on an officer, tapping them on the shoulder, spitting, throwing an onion ring, carries a mandatory minimum punishment of 6 months in jail and a felony record when that happens. This gets them, stops them from being able to receive public services, employment, social support if they have a felony conviction. This further exacerbates trauma that is experienced by these individuals. We have been working for years to help our autistic community be more give them more rights to live a life like, that they wish for. I know we have a number of people who are here. I've been working with their families for, going on 10 years at this point, and I know that there are folks here who would like to speak to the bill.
Great. Any questions for Senator Boysko before we go to support and opposition? Okay, Senator Stewart has a question for you, Senator Boysko.
Senator Boysko, I actually carried years ago and worked really hard to expand the ability to take things under advisement for people on the autistic spectrum disorder. And I both defended them and prosecuted them over the years. And I just want to make sure you understand what this does. If we adopt this, then they are just not, they're not going to be charged with anything. They're not guilty as an affirmative defense. Under the advisement provision that I work to get, we actually then have the ability for the court to get them services and get them help and help them get through whatever their issues are. And if the court doesn't have that ability, oftentimes they just get lost in the community again. And that gives me a lot of concern because a lot of times these children, and I'll use children as anybody under 20 years old in the court system, don't have the support that they need, don't have people to help them, and the only way we can figure out how to help them is when they get caught up in the judicial system. And there's already a provision that says if you're on the spectrum and you commit a crime, We can take it under advisement and drop the case, but we get you the services you need. And in this bill, you're not going to be able to get them any services.
Senator Boysko.
Mr. Chair, Senator Stewart, I would ask clarification from the clerk because that is not the intention here. And I appreciate and I supported your bill, and I think I was your co-patron. This is something that I think was a great move. However, these individuals who are found guilty of a simple assault are subject to a mandatory minimum that the judges do not have any ability to make a decision about. That's my understanding. That's why I brought the bill forward. And I would
Senator
ask.
Boysko, I think your bill is much broader than autism. It covers other forms of mental illness, intellectual developmental disability besides autism, and also, I believe, under Senator Stewart's bill, which is only about autism but covers all crimes and not just this crime, if I'm not mistaken. The person has to stipulate they're guilty in order to get deferral, which makes them ineligible for an expungement, whereas this creates a pathway to not guilty, which would allow somebody to get a full expungement if they were to be found not guilty. I think those are some differences.
I had a bill that dealt with folks on the autistic spectrum and other diagnosis of certain mental illnesses, and then Senator McClellan, when she was here, I think we were still in the Science Center, she had a bill which broadened it significantly beyond mine that I worked with her on and supported. And I'm not opposed to the concept. What I'm concerned about is if there's an affirmative defense to this, they're not going to be charged, they're not going to be prosecuted, then you don't have what you need to get them services. That's what I'm worried about.
Mr. Chairman,
Mr. Benjamin has a...
Mr. Chairman, I think that the bill permits somebody to be arrested and charged and prosecuted. This bill, the amendment clarifies that it's an affirmative defense, which would be similar to self-defense, for example. You can be prosecuted and tried, but if you elect, you may mount the affirmative defense. It's your burden as a defendant that you fall under one of these categories.
Mr. Chairman.
Senator Stewart.
And so Mr. Benjamin's a much better lawyer than I am, but practically speaking, why would I go under the advisement statute and accept the services of the court when I know I have an affirmative defense and I'm going to win? That's what I'm trying to say.
Yeah, Mr. Chairman, yeah. Senator Stewart asked a good question, and the answer may be that you don't want to incur the risk of going to trial. You don't want to incur the risk of your affirmative defense being rejected. You may not be able to afford to mount an affirmative defense. There are many reasons why an individual, Mr. Chairman, Senator Stewart, would prefer to have a matter taken under advisement because of the certainty of that sort of disposition.
I think Senator Perry has a point she wants to make. Senator Perry.
Mr. Chairman, Senator Boysko, I spent some time as a prosecutor working extensively with our mental health and with our crisis intervention training law enforcement officers. I still work in that program for when they respond out sometimes to incidents like this, and I'm incredibly sympathetic to this problem. I've spent a lot of time trying to deal with this problem, and to be honest, I agree with you. I don't think our criminal justice system does a great job. I think that's what Senator Stewart is also referencing as well, dealing with in particular folks who have developmental disabilities or who are on the autism spectrum. One of my concerns is I know you said some things if an individual is in the middle of what I'll call a crisis and they slap someone but they didn't mean to. I'll say a couple of things about that. I don't think that would be covered under this bill, and I don't think the person could be charged because that would be. It wouldn't qualify. You still have to have the intent, right? The intent to hit someone. So if you don't have the intent, I don't think you would be charged. And if you were, we did pass, or this body passed the diminished capacity bill that would provide for the defense, just like this does, a defense. And it says, hey, those cut against if you were diagnosed at the time, and as a result of that, you don't have the intent to do something, then it would be covered in that way. My concern is that it was not uncommon that people would get ECO'd or TDO'd, emergency commitment order, or temporary detention order for sometimes we don't know what's going on, right? It could be a mental illness. It could be, an autistic someone who is autistic. It also, we often, those are often served on also people who are intoxicated or who are under the effects of usually illicit drugs like PCP and things like that. The way that this bill reads, it says, the officer was responding to a request for service and the individual's behaviors were consistent with a mental illness, that's A, or an intellectual disability, and it goes on. There are certainly people who are on drugs or who are on alcohol, like I said, who actually qualify for emergency commitment orders, but not because they're suffering from a serious mental illness, which is what would be required under the law, but because they're on substances. And under this bill, the way that I read it, you could be voluntarily intoxicated, and all that's required is that your symptoms appear as if you're suffering from a mental illness or appear that you are suffering from an intellectual development disability. And that's not an uncommon situation that happens. Like I said, we often ECO those people because we just don't know when we're responding to a crisis situation. And so what I'm concerned about is that the affirmative defense that's now been provided to those people, because you don't have to prove that you have one of these things. You just have to prove that you had symptoms that were consistent with one of these things. And so I guess my question is that the intention of the bill?
Senator Boyce.
Senator, Mr. Chair and Senator Perry, there has been, and it should be in here as well, that being intoxicated is not part of getting you the affirmative defense. The point of this, and I would like to have my folks come up and speak to it. We have been working on this for a number of years. There are individuals who end up in the criminal justice system who are put in prison, who absolutely were not in possession of their ability to control themselves, and they lose their benefits. They lose the ability to they have a felony charge that follows them through the rest of their lives. This is an attempt to try to remedy that, and I would like to have some folks who have been spending their entire lives on this, and they might be able to answer some of your questions better. And if somehow in the nature of the substitute left out the piece around intoxication, I would consider that a friendly amendment because it absolutely was in the original part of my bill. Again, they can be arrested, and then the magistrate can assess better the state of the situation. So I would ask the chair to allow my folks to come speak.
Okay, MJ, why don't we set it for 5 and 5? Okay.
If there's anyone online that would like to speak in favor, please raise your hand.
Okay.
Brian Kelmar with Decriminalized Developmental Disabilities. When someone has a medical emergency, they call for help and an ambulance arrives. When families with intellectual developmental disabilities such as autism call for help, they think that they're in a desperate situation, and they think that they're doing the right thing for crying out for help. What happens, though, is rather than a medical response, there's a law enforcement response, even with 988. People with autism have sensory issues, they have overload issues, their fight or flight reactions can overpower their executive functioning. This can make they can feel overwhelmed and trigger a fight or flight response when in an encounter with the law enforcement. Instead of getting help, they can end up in jail for weeks. This is shattering for the individual, but most importantly, the family. Mentally, emotionally, and financially devastating, costing lawyer costs of $40,000 to $50,000 for legal fees, bail, psychological evaluations, etc. The family's initial cry for help has now turned into a nightmare. Long-term consequences are even much more severe than the original meltdown that prompted the call for help. The autistic person can be traumatized by the event for life, resulting in new issues such as PTSD, depression, and anxiety, etc. These situations can also be overwhelming for an autistic to handle, leading to attempted suicide or committing suicide. Suicide rates for autistics is already 3 times higher than a neurotypical. Convictions are more importantly devastating for life. They lose access to vital support services that we've talked about here for autistic people already in trouble. Unemployment rates for autistics is 85. With convictions, it's 99%. In an ideal world, 988 or train on law enforcement area can help. In reality, this is not solving the issue of the impact when assaults do and are occurring. This is for families who fall through the cracks. Families in this situation need the right help right now, not long-term discussion. We strongly support this bill.
Thank you, sir. Next up, we got 248, and probably have people online, probably. So.
Good morning. My name is Martin Mash with Vocal Virginia. We are Virginia's only 100% peer-run and staffed mental health advocacy and education program. We support this bill because we believe that it works to destigmatize mental health challenges as well as decriminalizing the mental health process for those who are struggling.
Thank you. Next up.
Good morning, Mr. Chairman, members of the committee. Ashley Wright, representing the ARC of Virginia. We're very grateful to Senator Boysko for working with families on this issue. We wholeheartedly support the bill and associate ourselves with the comments made before.
Thank you.
Good morning, Mr. Chairman, members of the committee. I'm Colleen Miller from the Disability Law Center of Virginia, and we support this bill.
Morning, Mr. Chair. Rob Hogenclass from Justice Forward, Virginia. We strongly support the bill. Thank you.
Wow, we're moving.
Yeah, good morning. Good morning, Mr. Chairman. Bruce Cruiser with Mental Health America, Virginia. We support the bill. I think the ultimate goal is to divert people with a serious mental illness who are in crisis from the criminal justice system altogether. However, this is a good step in the right direction. We appreciate the patrons' work on this. Thank you.
All right, thank you. Next up.
Good morning. Good morning, Sheba Williams with No Left Turns, but I'm also the mother of a 22-year-old who has autism, and he is what we consider high functioning. So it is not always recognizable that he is having an episode with his echolea or things like that. And we saw in the case of Matthew Russian where he was sentenced to 50 years for a car accident. So we support this bill, and in a personal capacity, it would prevent someone like my child from being criminalized for something that is not necessarily recognizable and not always a visible physical disability. Thank you.
Thank you, Ms. Williams. I think we have people online too, probably, right?
Mr. Chair, there are 3 people online that would like to speak. Janine Rosaldo, please unmute and make sure your camera's on.
Good morning, members. My name is Janine Rosado, and I'm the mother of a child that has autism and intellectual disabilities. And we're currently going through this process ourselves in Henrico County, where we called to get some assistance for my son calling 911. And instead of him being TDO'd to a hospital, he's being criminalized and was sent to jail. So we're in favor of supporting this 357 bill. Thank you.
Teresa Champion, you are next.
Hi, good morning. Teresa Champion with the Virginia Autism Project. I'm in Springfield. Ladies and gentlemen, you may think the judicial system helps these people. It does not. JLARC has said that Virginia sends neurodevelopmental disorders to state hospitals inappropriately. Jails are not appropriate. State mental hospitals are not appropriate. Let's stop arresting them. We support this bill. Thank you.
Zachary Cummings, you're next.
Time's expired, so if you could be really quick.
And please make sure your camera's on.
Okay, let's move on to opposition then. It looks like he's not there. We reset the timer, and anybody opposed the bill, come on up.
If there's anyone online that would like to speak in opposition, please raise your hand.
Good morning, Senator Sorvell. My name is Bethany Harrison. I'm the Commonwealth's attorney for the city of Lynchburg here on behalf of the Virginia Association of Commonwealth Attorneys in opposition to Senate Bill 357 for the following reasons. First of all, people already have this defense available to them under 19.2-271.6, which is the diminished capacity defense. However, this bill would create an inconsistent evidentiary standard for those who commit assault or assault and battery on a law enforcement officer, in that under the current diminished capacity defense, the standard is the person must satisfy diagnostic criteria for the defense to apply. Under this bill, that standard would be different only if your victim is a law enforcement officer, and that standard would be behaviors consistent with mental illness. Not that you satisfy diagnostic criteria, but that you have behaviors consistent with mental illness. Also, there is disparate treatment of victims here. You have a law enforcement officer under this code section, under 18.2-57C. This is what we seek to amend with this bill. You have also, under the same code section, judges, magistrates, firefighters, and EMS. But only law enforcement officers would be victims under this, where there would be an affirmative defense under this bill. For what has been purported to be the reasons for this bill, you would frequently have at these calls for service firefighters or EMS available, and someone could commit an assault or assault and battery against a law enforcement officer and also commit it against the EMS technician. And for the EMS technician as a victim, the person faces the 6-month mandatory minimum, but not for the law enforcement officer. So for those reasons, we oppose the bill.
Mr. Benjamin, I got a quick question for you or Ms. May, one of you guys. So if you're charged with assault on an LEO under this and you were to prevail on the affirmative defense, you could still be found guilty of regular A and B, right? Because that's a lesser included of this. This is only a defense to the felony charge, right?
Mr. Chair, that would be my understanding, since it is a lesser included of the assault and battery of law enforcement.
I mean, that A and B is a lesser included of this. They can find you guilty of a lesser offense. Sure, Senator Stewart, go ahead.
Mr. Chairman, I was listening to the young lady who testified a minute ago, and while I'm looking at this, if you don't present any behaviors consistent with one of the two things, then you don't get this. Is that correct? So if you're not exhibiting the behaviors of someone with a mental illness or autism, then under the bill as it's written, you would not get the benefit of this? Somebody help me with that.
Mr. Chair, the substitute says specifically that the individual's behaviors must be consistent with the mental illness as described as in 19.2-271.6 or intellectual disability described in 37.2-100, such as autism, including that, or the individual meets the criteria for issuance of an emergency custody order pursuant to 37.2-808.
So, Mr. Chairman,
Senator Stewart,
if you are not, so you think it falls under the final provision as the catch-all? Because if you're not, it clearly doesn't if it's under, a lot of autistic children are very stoic, and they don't show emotions, and they don't, the gentleman was right, it's all about fight or flight for them, but sometimes they just don't show anything. And I don't think they get the benefit under this, if that's what you're trying to do. Maybe somebody else can look at it differently.
Mr. Chairman.
Sorry, Senator Perry, you got an answer for Senator Stewart?
I think so. Senator Stewart, I think you're right. And unfortunately, and I think this is probably a portion of the law that needs to be fixed, under the emergency custody orders, right? Under that section, you have to suffer from a serious mental illness. And autism spectrum disorder does not qualify under that statute. I hate to say it, but I think it should. That's just not the way the law is written.
Mr. Chair.
Yeah, Senator Boysko.
Would the body entertain a friendly amendment that on line 39 were consistent with, and then add new language, or received a diagnosis for? Would that help clarify? And again, I would just remind the body that this is only if someone is coming at the request of, the officer is only, he is responding to a request for service because the individual's behavior is consistent with these issues. This is not just if you're out on the street.
Senator Stewart.
I think you would have to say we're consistent with and have been diagnosed with, not or. I think you have to have both.
Looks like Mr. Mr. Carol Foy, do you have something you want to say? No, okay. Okay,
I'm not on board with the policy yet completely because I think it's going to hurt the work that we've already done, but at least I'd like to see it right if it's going to pass, and I sense it's going to pass.
Yeah, Mr. Chair, Senator Stewart, the situation we're trying to avoid is if someone has the experience of being a person with mental illness or the experience of being someone with an intellectual or developmental disability, but because of indigence or some other reason has not received the official diagnosis and maybe can't afford to receive the official diagnosis, and then trial proceeds quickly and they're not able to get to that in order to present the affirmative defense. That's the situation we're trying to avoid.
Senator Stewart's in the middle of the cross.
That is exactly what scares me about this bill. You said it better than I could. Because under the law as it is today, we're going to figure that out and we're going to get them help. And at the end of the day, the charge is going to be dismissed. And that is why I'm afraid of what you're trying to do here.
Okay, Senator Carol Foy, I think.
Yes.
Yeah.
Thank you, Mr. Chairman. So I have a question. So under 19.2-271.6, that has a notice requirement and a requirement, and it makes reference to expert witness to testify in order to take advantage of that code section. Is that correct?
That's my understanding, yes.
Okay. And so what this does is that there are oftentimes people who are street homeless, don't have access to health insurance, so they don't have the luxury of going to see a psychiatrist or a therapist and being diagnosed and being treated. Is that correct?
Mr. Chair, Senator Carol Foy, yes.
And
Senator Carol Foy, make sure you go through the chair.
Thank you, Mr. Chairman. Mr. Chairman, follow up?
Go ahead.
And isn't it true that oftentimes clients come into the indigent defense with dual diagnoses, meaning they suffer from mental illness and they may have a substance abuse addiction at the same time?
Mr. Chair, Senator Carol Foy, that certainly was my experience as a public defender, yes.
Mr. Chairman, follow up?
Senator Carol Foy.
And isn't it true that oftentimes indigent people cannot afford medication, so they self-medicate with street narcotics? Is that correct?
Mr. Chair, Senator Carol Foy, that is absolutely true.
Mr. Chairman, one last follow-up.
Yep, Senator Carol Foy, go ahead.
And can't oftentimes health complications cause a psychosis, such as untreated urinary tract infection that can cause paranoia, hallucinations, and psychosis?
Mr. Chair, Senator Carol Foy, that one's outside the reach of my expertise, but I understand what the senator is getting
Mr. Chair, very quickly.
Yeah, Senator Carol Foy, go
I've
ahead.
had a client who had that, right? And so I appreciate the patron for bringing this bill. What we want to do is ensure that people who may have in the letter of the law committed a crime, in the spirit they have not, because they were not able to form the intent. And instead, and I appreciate some members who believe that our indigent civilians and our people are not charged with these crimes because they shouldn't be, but I can tell you as a practicing public defender for many years, they are. And so police are responding out to people having mental health emergencies. Under an emergency custody order or a temporary detention order, they're taken into custody against their will. Oftentimes, a foot is stepped on or something of that nature happens, and we want to make sure that these people are not convicted. Now, to address the concerns that some of the members have, if they are if an emergency custody order or temporary detention order is why they are having contact with law enforcement, then services can be provided, and oftentimes are, and community service boards and wraparound services are initiated. So we don't want people to have convictions in order to get treatment and services. We know that our jails are the #1 provider for mental health services in the Commonwealth of Virginia, and that is abhorrent to me. So I hope that everyone can support this bill. I thank the patron for bringing this bill, and I will be supporting it as written.
Thank you, Senator Carol Foy. And I would just note that I'm pretty sure that a lot of times in order to prove this affirmative defense, the defendant's probably going to have expert testimony to establish that the behavior is connected to a mental illness. And so I think, there'll probably be a doctor there involved. Not necessarily, but a lot of times to prove it. So, and if they're indigent, they could get access to that. So we're back to the opposition. AG's office, opposed?
Mr. Chair, committee members.
members, thank you. The Attorney General respectfully opposes this bill. We understand completely Senator Boysko's intent in bringing the bill, and thank her for advancing the ball here. But the procedures of 19.271.6 need to be followed if this kind of evidence is going to be introduced. Evidence that is merely consistent with mental illness is creating a separate track for only assault and battery on a law enforcement officer. So for that reason, we would ask that the committee not report the bill and allow the carefully crafted procedures of 271.6 to control in these situations. Thank you.
Thank you. Okay. Administration.
Mr. Chairman, members of the committee, Josh Humphreys, Deputy Secretary of Public Safety. We haven't had a chance to adequately review the substitute. I originally came here to oppose the version as drafted, but certainly think that the concerns of VACA and the AG's office and others are well noted, and we would just encourage some further work on this one.
Hey, Senator Boyce, got another question for you based on the testimony from VACA. The Commonwealth attorneys pointed out that the affirmative defense only applies to law enforcement officers, but not all of the other personnel listed who often come into contact with mentally ill people. I was just curious if that was intentional, whether you were hoping to pick up everybody who's covered in this felony subsection.
Mr. Chair, I'd be happy if you'd like to make a motion to include those.
Okay. Mr. Benjamin or Ms. May, is there some way we could just say assault and battery of any person under this subsection or something like that? Would that take care of it?
Yes, Mr. Chair, I think you could just strike for assault or assault and battery of a law enforcement officer under this subsection. It would just be to prosecution of an individual under this subsection, or you could keep for assault or assault and battery under this subsection, just strike law enforcement officer.
Okay. Is anybody else want to make that motion? Are they okay with that?
So moved.
Okay. It's been moved and seconded by Senator Perry. We make that motion. Any discussion? All those in favor say aye.
Aye.
Aye. Anybody opposed? No. Okay. Senator Boysko. Oh, I'm sorry. Is there anybody else online that's opposed?
Zachary Cummings, you may unmute.
No, Mr. Cummings. Does this one go to finance?
I'm sorry, Mr. Chairman, I just have a question.
Nope. Senator Perry, I'm sorry, Ms. May.
Mr. Chair, I just wanted to check whether Senator Boysko still wanted to add back that language about the voluntary intoxication. No. Okay. And one more clarifying question. In light of the amendments, on line 38 of the substitute, it still requires the officer was responding to a request for service. With the committee, we just change it to the individual was responding to a request for service with the understanding that that's not probably going to apply for all of the individuals in that subsection. But
Yeah, I think we need to make that amendment too. So Senator Perry moves and Senator Carol Floyd, I think, seconds to change it from officer to individual on line 38. Yes. All those in favor say aye. Aye. Anybody opposed? No. Okay. Senator Boysko, the bill's before us. If you want to have the voluntary intoxication discussion, that's a bigger, more complicated discussion. I don't know if you want to take it by to have that or get this out of here. It looks like there's some more questions down here.
If I could just ask a question.
Senator Perry, go ahead.
Mr. Chairman, Senator Boysko, just so I understand, and I apologize because the bill that I reviewed last night is very different from this bill. So I guess my question is, under the way that I read 19.271.6, the diminished capacity defense, right? It was meant to, at least initially my thought was it was meant to cover situations just like this, right? It changed Virginia law that had been Virginia law for many, many years, right? To allow this other evidence to come into courts that juries or judges could then consider related to things like autism spectrum disorder, related to mental illness, right? If you weren't incompetent or insane, met any of those definitions. So you weren't trying to introduce that evidence. I guess my question is the way that this bill reads now, and I'll be honest, I think it's a little weird to have someone called to you. It's not uncommon that law enforcement might encounter someone on the street who might be suffering from a mental illness or some other way. Maybe no one called them, right? So are those people cut out of this bill? Maybe. So I guess my question is, what are you trying to get at with this bill, the 19.2 271.6 diminished capacity does not already cover. Because I think diminished capacity would give jurors and judges the ability to amend to a lesser included. And of course, this is if prosecutors haven't gotten rid of this, other people haven't gone through and gotten rid of the charges, right? If we get all the way down to the end of the line, which is what I think this bill is attempting to address, what is it that this does that 271.6 doesn't do that wouldn't allow for the courts, the jury to find the person not guilty, right? Or that wouldn't allow for an amendment to the cascading instruction of assault and battery, a misdemeanor offense? Can you help me with that?
Mr. Chair, Senator Perry, if I may, in speaking with public defenders around the Commonwealth, we're not aware of a single case where a person with one of these conditions was able to use 19.271.6 as a defense that reduced the charge to a lesser included.
And Mr. Chairman,
Senator Perry,
I looked through the financial statement and I saw that in the fiscal impact statement may not apply to this bill anymore. It looks like it was the same one I looked at last night, so I'm not 100% certain. But it looked like the initial estimate that was that there would be 289 people who would not have been convicted if this law was in effect. But of course, that was the law from last night, as I'll call it, which was very different from this bill. And so when you say no one was able to use it, I guess my question becomes, look, I know Loudoun County, right? I don't know a lot of the other jurisdictions, but I've never seen, nor would I imagine to see, a case like this that would have gone to a judge or a jury on a felony assault and battery. And so I guess my question becomes, why is that? Why is 271.6 not effective as you see it? Or is it because no one's using it because no one gets there?
Mr. Pogenglass.
Mr. Chair, I really don't want to sound flip. I understand Senator Perry's concerns. I just, in speaking with folks in other jurisdictions, I don't think Loudoun is representative of the entire Commonwealth in terms of how these cases are handled.
And so, can you answer the
Senator
question?
Perry.
I'm sorry, Mr. Chairman. Can you help me understand what is it with 271.6? In your view, that is it? I guess is it a question of they're not getting to that far, or the statute isn't working the way you had hoped?
Mr. Chair, Senator Perry, I think it's the latter.
And can you explain to me why that is?
I'm sorry, I'm not practicing now, so I haven't had the chance to use it, so I don't have the experience of Andy or Brad or someone else who could answer that question.
Mr. Chairman?
Senator Perry. I'm sorry.
The other Perry.
I'm sorry. I wasn't looking. Senator Carol Foy.
Yes, thank you, Mr. Chairman. So I think I can help answer this question because I've actually come in contact with this and tried to utilize this code section for one of my mentally ill clients. The challenge is that of the requirements of the current code section. So there's a notice requirement. There is an expert witness that is needed and helpful to testify. And oftentimes when we have these indigent clients, tracking down their records is very difficult, if not impossible. You have to siphon through bureaucracy and trying to get this mentally ill client, who sometimes isn't even in your jurisdiction, to sign a release of information, to get it to the location of the person's medical records. You didn't have to try to subpoena and pay for someone to come testify in support of this code section. So now you have to apply for expert witness funds. So there are a lot of barriers and challenges and hoops that defense attorneys have to jump through in order for this code section to even be applicable. So if nothing else, what this does that the patron is brought forth, which I appreciate, it makes it a lighter load on defense attorneys. And when we have clients who are suffering from serious mental illness or intellectual disability, shouldn't we want justice for them? Do we want to make things more difficult? I don't think that's the standard. The standard is, if the person didn't have the mens rea, the intent to commit this crime, let's make it easy for defense attorneys to be able to prove that in court and not more difficult and more costly and almost impossible. Thank you, Mr. Chairman.
Mr. Chair, I'll just point out.
Okay, Senator Boysko. Yep.
Mr. Chair, we started working on this 4 years ago with just removing the mandatory minimum for a simple assault on a law enforcement officer.
Remember it well.
And we have passed that language in previous sessions. This was an attempt to rein it in, to make it only applicable because there were some concerns that were raised, and we reined it in so that it was only in response to someone calling for help when there is an individual who is in crisis, as a way to say we are acknowledging the fact that there are specific folks who really are most likely at harm from this provision. And that is why we are in the posture that we are in today, because we were trying to take into consideration individual members and outside groups' concerns about the full stop, just removing the mandatory minimum on this situation.
Okay, thank you, Senator Boysko. Senator Bagby has moved the bill be reported. Is there a second? Second. It's been seconded. I don't think it has to go to finance. Clerk will open the roll.
Thank you.
Ayes 9, no 6.
Great. Senator Bagby has been waiting for an hour to present his bill.
Maybe longer.
Senator Bagby, you got, what do you got? Senate Bill
625.
625, deferred or installment payment agreements, maximum amount to be paid.
Thank you, Mr. Chair. I almost forgot what this bill does, but I think it'll be really easy on this committee to catch up. This bill sets out a process to make sure that Virginia courts are aware of and implement the protection of Social Security income from being taken from individuals by any legal process. And so it sets up a deferment.
Oh, we got a substitute?
Yeah.
Okay, Senator Bagby moves, Senator Deeds seconds. We adopt the substitute. All those in favor say aye. Aye. Anybody opposed? Nobody's opposed. Okay, substitute adopted.
Thank you, thank you. And so, Mr. Chair, this legislation simply sets up a deferment for individuals that are sole income is based upon Social Security benefits or supplemental security income. And that's what the bill does, Mr. Chair.
So it's trying to keep anybody from garnishing SSI income for fine payments, right?
So that's all it does.
Okay.
And it defers it.
Any questions, Senator Bagby? Anybody testify in favor of the bill?
If there's anyone online that would like to speak in favor of the bill, please raise your hand.
Might be, I don't know, might be. Sabrina, is this already federal law?
Mr. Chair, I am not sure, but I can look into it.
Great, thank you. Okay, I'm not putting a timer on because you're going to be quick, right? Okay, we'll go 2 per side, okay? You can be quick.
Good morning, Mr. Chair, committee members. I'm Pat Levy-Lavelle, an attorney with Legal Aid Justice Center. We support this bill because it enacts procedures for Virginia courts to help ensure that they comply with the federal anti-alienation provision of the Social Security Act. Right now, a lot of courts in practice are not connecting the dots to implement that relief for folks. This simply puts in procedures that assist them in connecting those dots so that folks get that relief.
So, Mr. Chair,
just
so I can understand, federal law already prevents or says you're not supposed to take Social Security benefits. This just implements federal law.
That's correct.
Okay.
Thank you.
You guys really need to testify in favor of it? I think you're all in good shape here, okay? Okay, anybody opposed? Okay. And does this have to go to, okay, let's go to finance. So it's been moved. Senator Bagby moves, Senator Deeds seconds to move and refer the bill to finance. Clerk, open the roll. Hey, Bagby, you need to revoke your proxy tonight in a second. I got you.
Ayes 15, no 0.
Great, thank you. Next up. That was quick. Put that on your brochure. Senator Obenchain has a quick one, I think. He wanted to try and knock out. Where was that?
Mr. Chairman, Senate Bill
573.
Yeah. This would create the public safety communications infrastructure and grant fund, not necessarily funded, but many jurisdictions around Virginia are small. Many are not small, but experiencing fiscal stress. This creates a process by which this fund, once it is funded, would either award grants to local governments or make low interest or zero interest loans to local governments for the purpose of purchasing public safety communications equipment.
Mr. Chair.
Senator Deeds.
Mr. Chair, I would ask Senator Obenchain, would this loan money supplant the $33 million that we read about in the Richmond paper the other day that the Department of Emergency Management squandered?
This has nothing to do with that. This is for interagency communications.
Isn't that also communications money in part?
It may very well be, but that money is clearly not. I don't know. I don't know enough to comment on that, Mr. Senator Deeds. But I represent counties like Page. Used to represent Rappahannock, represent Bath and Highland. I know that those jurisdictions are struggling to fund communications equipment that sometimes runs into the tens of millions of dollars. They don't have the means of doing it. There was no money that was available through the Department of Emergency Services or elsewhere to provide grants or low-interest loans for it. This is going to provide that assistance for any jurisdiction, whether it's rural or urban. If you don't want to help these jurisdictions, don't vote for it. But it provides a means of addressing this very real challenge. And I understand the political point there.
Senator Deeds. I want to help these jurisdictions. Did this contain any funding in the governor's budget?
This isn't an administration bill. This is my bill for jurisdictions that are small and jurisdictions experiencing fiscal stress. I put in a budget amendment to create the fund of $100,000, which is basically what the fiscal impact statement said. I would ask that there be one amendment made to the bill that would give the Virginia VRA the administrative responsibility, both with respect to administering the grants and the fund. Currently, as drafted, it simply is administering the money, but they have the capacity to administer the grants as well, and that would reduce the fiscal impact and put the responsibility for administration of it in some place that may be more satisfactory to my friend from Charlottesville.
Sarah, which I think on line,
Mr. Chair.
On line 20, I think it already has the VRA listed there. And we'll go to
it does, but that the VRA is responsible for fiscal management. As drafted, it is to be administered by the Department of Emergency Management. My requested amendment would essentially say shall be administered and fiscally managed by the Virginia Resources Authority.
Okay. Okay, hold on.
Mr. Chair?
Is that on his requested amendment? Mm-hmm. Okay, Senator Jordan.
Just speaking of the bill, I think that Senator Deeds raised a question about Senator Obenchain's bill in regards to money being squandered. I think you're talking about the Office of EMS that had an issue with funding. This is drawn to VDEM, so separate agencies. I just wanted to point that out for everyone in the audience. But a question for Senator Obenchain.
Senator Jordan, go ahead.
I believe I know the answer to this, but I think it would be helpful for those that are on the committee. So currently, right now, public safety infrastructure, since almost 2001, post-September 11th, there was a ton of Homeland Security funds that came into flux in Virginia that were able to allow different areas to be able to enhance their radio telecommunications. Since then, we have adjacent counties that aren't just rural, but suburban and urban that have different styles of infrastructure, so they may not be able to operate even on the same radio channel. Is that the intention of your bill?
Yeah, that is part of the intention of the bill. Many of these changes are mandated. They are necessary for compliance with federal law and for public safety in these communities and many of these local governments, urban and rural, just don't have the resources to do this and need some help.
Okay. Senator Jordan, done? Got it. Senator Obenchain wanted to make an amendment, I think, on line 20, wasn't it, or 2019?
Senator Stewart will second.
Okay. Senator Obenchain moves, Senator Stewart seconds to amend it from the Department of Emergency Management to, well, it's not quite that clean, but I think we got the idea.
Shall be
Got it.
administered and financially managed by.
It just delete by the Department of Emergency Management, the department, and just,
Correct.
yeah, okay.
And
So move
Mr.
to second, yep.
Mr. Chair, I just want to check a few other places, see if Senator Obenchain, down in subsection B, where it also talks about the Public Safety Communications Program on line 40, says the program shall be administered by the department, and that references to Department of Emergency Management. We also want the program to be administered by, so strike anywhere it basically says the
And on line
administered.
51 as well, it talks
Okay.
about the department.
Yeah, okay. All those in favor of that amendment, say aye. Aye. Anybody opposed? No. Is there a motion on the bill?
Move to report and refer to finance.
It's moved in second, refer to finance. Can you please open the roll?
My apologies.
We gotta strike it or something? What was it? Okay, there we go.
It's not that.
There you go.
Ayes 15, no zero.
Okay, so, thank you. That's reported and referred. Now, Senator Perry, your compensation and court-appointed counsel, is that ready to go today? Okay, so we have that. If Senator Jordan, Salim, you've got a few, right? Or just one? Carol.
Both mine are going to go to finance.
394. Okay, well, we're all backed up in this lovely committee. McDougall, have you done yours yet? Okay, let's see. What has finance impacts? Deeds, Carol Foy, and Perry. Carol Foy seems really eager to do hers. I don't think you've got to do one yet. Why don't you go first? Listen, I have a bill that's on the dock for the third time today, so.
Well, you've got to be here.
Good morning, Chairman and members of the committee. Before I begin, I would like to move the line amendment. Could the clerk please report the amendment?
Okay, this is 491 for those following at home.
Yes, Mr. Chair. These are just a couple of technical amendments. The first is on line 26. After A, we're going to strike product and insert firearm ammunition, a firearm component, including unfinished firearm frames or receivers, or a firearm accessory. Effectively, that moves the definition of product from lines 34 and 35 up into the definition of firearm-related product on lines 26. And again, we're going to strike all of lines 34 and 35. And on line 89, after section, we're going to strike may and insert shall.
Okay, Senator Carol Foy moves, Senator Subramanian seconds. Those line amendments, all those in favor say aye. Aye. Anybody opposed? No. Senator Carol Foy, you got an amended bill before us that's similar to a bill you heard last year, but a little bit different. So can you, and
Yes, thank you,
a bunch of new committee members too. So what does your bill do?
Yes. So since 2020, guns have been the leading cause of death for kids, teens, and young adults. According to the CDC, 43,375 people die by guns in the United States in an average year. In Virginia, that number is 1,121. Virginia has the 36th highest rate of gun deaths in the United States. The rate of gun deaths in the Commonwealth has increased notably by 42% from 2012 to 2021. Notably, in 2000, Smith & Wesson agreed to develop a smart gun with fingerprint recognition, a code of conduct for gun dealers to prevent theft and gun trafficking, and stop making new guns that can hold more than 10 rounds of ammunition as a way to mitigate the hurt and harm being caused by the industry's current practices. Unfortunately, the agreement didn't come to fruition, but it does show that it's possible and even recommended by one of the largest gun manufacturers that these better industry practices can be implemented. Today, the public cannot mandate that gun manufacturers implement these common sense gun safety measures because they don't have to. This bill arises because since 2005, dangerous actors in the gun industry have been shielded from accountability for their practices by the PLACA, Protection of Lawful Commerce in Arms Act, a unique federal law that offers protections not available to makers or vendors in the automobile, tobacco, or opioid industries. We are able to regulate everything from tires to tobacco to teddy bears, but not the gun industry. The gun industry enjoys exclusive immunity and are shielded from liability from the death and destruction their products cause. They are not forced or encouraged to implement better industry practices or standards because there is no option to sue. And so what this bill does is create that necessary option. Senate Bill 491 creates standards of responsible conduct for firearm industry members and requires such members to establish and implement reasonable controls regarding the manufacture, sale, distribution, use, and marketing of the firearm industry members' firearm-related products. Such reasonable controls includes the reasonable procedures, safeguards, and business practices that are designed to prevent the sale or distribution of a firearm-related product to those already prohibited from possessing a firearm under state or federal law, prevent the loss or theft of a firearm-related product from a firearm industry member, ensure that the firearm industry member complies with all provisions of state and federal law, and does not otherwise promote the unlawful manufacture, sale, possession, marketing, or use of a firearm-related product, and ensure the firearm industry member does not engage in practices that violate the Virginia Consumer Protection Act. This bill also provides that a firearm industry member may not knowingly or recklessly create, maintain, or contribute to a public nuisance as defined in the bill through the sale, manufacturing, importing, or marketing of a firearm-related product. The bill creates a civil cause of action for the Attorney General or local, county, or city attorney to enforce the provisions of the bill, or for any person who has been injured as a result of a firearm industry member's violation to seek an injunction and to recover costs and damages.
Mr. Chair.
Senator Deeds.
My question's for Mr. Benjamin. You know, as I look at this bill, it's similar to what we had last year. The public nuisance is new, and I'm interested in language on page or on line 38. A public nuisance under common law, is that pretty well defined? Are we able to look somewhere and figure out what that is?
Mr. Chairman, it's not well defined. I found one Virginia Supreme Court case from 1990 that defined a public nuisance as a condition that is a danger to the public.
Okay. Any other questions for Senator Carol Foy before we take four?
And I should also point out, Mr. Chairman, that maintaining a public nuisance is a common law offense, hence criminal.
It's a criminal offense.
It could be prosecuted as a criminal offense under the common law.
It's also an exception from sovereign immunity for municipalities. Municipalities, not the state. Okay, any other questions for Senator Carol Foy? Nope. Okay, let's go 5 and 5. All those in support?
If there's anyone online that would like to speak in
Bob
favor,
Barker
please
says,
raise your
come on
hand.
down.
Mr. Chairman, members of the committee, Jennifer Vanny, Fairfax County. Creating standards of conduct for members of the firearm industry is a common sense measure that will increase safety, and Fairfax County supports this bill.
Thank you.
Good morning, Mr. Chair. Liddy Ballard from Brady. No industry should be above the law. This bill does not create strict liability or guarantee a favorable judgment and will not allow frivolous lawsuits to proceed. Instead, it holds the firearm industry to the same standards of all other industries. We urge you to vote in support of this bill. Thank you.
Thanks.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We see a lot of restrictions on products which were not intended to do any harm. Firearms are actually intended to fire bullets, and that's quite harmful if they go in the wrong direction. So we would support this bill. We also like the fact that the marketing of certain types of firearms to young men based upon their masculinity and things like that need to be wiped out. Thank you.
Good morning, Mr. Chairman, members of the committee. I fully support the bill. I think that protecting products makes no sense. I think lawsuits are meant to be available to consumers to protect themselves? What other means by which to highlight the injury that may be done? We support the bill. Thank you.
Hello, my name is Katie Long from Henrico County, a volunteer with Moms Demand Action, and we support this bill. Thank you.
Mr. Chair, there are 2 people online that would like to speak. Aaron, please unmute and make sure your camera's on.
Good morning, Mr. Chair. My name is Erin Earp. I'm a staff attorney with Giffords Law Center, and we support this bill. And I'd just like to stress that this is a bill that will incentivize firearm industry members to behave reasonably and to put reasonable controls in place to prevent firearms from getting into the hands of folks who should not have them, and to prevent people from being harmed. And we ask you favorably report this bill.
Virginia, please unmute and make sure your camera's on.
I'm Virginia Rovnak with the Charlottesville Coalition for Gun Violence Prevention and the Charlottesville Center for Peace and Justice. This is an important gun safety bill, and we strongly support it.
Thanks. Okay, let's reset the timer and go to all those opposed. Come on down and get them queued up online.
If there's anyone online that would like to speak in opposition, please raise your hand.
Phil Van Cleve, VCDL. So the war now on gun owners continues. This would be the equivalent of allowing people to sue Camry for people driving drunk. It's not the car manufacturer's fault if somebody gets drunk and misuses it. It's absolutely insane then to hold the gun manufacturers for what criminals do. It makes no sense. By the way, Smith & Wesson, when they tried to make that deal, at that time, they were mostly an American company. There was a period when they were British-owned, and that was when the British owned it. And right after they did that, they went basically had to sell the company and became an American firm again. The PLCAA, the protection that's provided federally, was put in place because of these frivolous lawsuits that were meant to do nothing more than destroy the firearms industry. So and I guess I would say finally that how is somebody selling an accessory like a brace or a magazine going to know that they're selling to a prohibited person? You don't run a background check for any of that stuff. How do you know? There would be no way for them to know. Thank you.
Good morning, Mr. Chair, members of the committee. Patricia Webb, Virginia Citizens Defense League, and also a licensed FFL. As Mr. Van Cleve mentioned, the Protection of Lawful Commerce in Arms Act was put in place to shield lawful business owners from frivolous lawsuits intended to litigate them out of business. It does not, I repeat, it does not in any way shield them from misconduct or wrongdoing. We see today firearms industry being faced with higher interest rates on loans simply because of the type of lawful business that they are conducting. They have problems finding credit card companies to process their transactions, banks to take their accounts. They are denied advertising. They're denied services for no reason other than somebody doesn't like their politics. And frankly, in America, that is not the way we should be operating. So FFLs today are tasked with ascertaining if the person that comes in to purchase a firearm or ammunition is conducting a straw purchase. We look at the circumstances and we make a decision. Under federal law, this is already, if we suspect a straw purchase, we are supposed to deny the sale, and we do. We don't want to see hands in the guns of criminals any more than you do. So I ask you to oppose this piece of legislation, which would legislate lawful businesses that bring tax dollars and safety to Virginia out of business. Thank you for your time.
Okay. NRA.
Mr. Chairman, Taylor McKee, National Rifle Association. We oppose this bill.
Thank you.
To the point. Okay, we got people online.
Mr. Chair, there's no one to speak in opposition online.
Okay. Mr. Benjamin, I got a question. So I've been poking around this whole public nuisance concept, and it appears to me that I've never really looked at this Title 48 very much, but there's a Title 48 on nuisances. And it appears to me that the only, whereas if you were to indict somebody for a public nuisance, it seems to me the only penalty is a fine under 48-5. Am I missing something?
Mr. Chairman, I'd have to pull that up. But unless something in the title you reference expressly abrogates the common law, then the common law could still be maintained. And I don't offhand remember what the penalty is for an unclassified offense.
Okay, thanks. I remember I've seen this. Actually, I looked at this title once before. Now that I think about it, because it's weird. I've seen it used twice. Once involved a sidewalk, where they actually impaneled a jury in Arlington to indict over this sidewalk somebody was mad about because it was misaligned or something. And then I saw it in the City of Falls Church. Somebody indicted for a public nuisance for them having too many gas generators creating lots of noise. And I think this is the process by which you can prosecute a public nuisance now. And I believe the only punishment is a fine. So it seems to me that doesn't really, unless somebody proves me otherwise, I think this sort of would pull gun shops into that box, so that if there's a gun shop that was like selling lots of guns inappropriately in violation of these liability standards, they could then be fined some money. At least that's the way I read this. Anyway, maybe somebody else can correct me. Senator Carol Foy, you want a final word? And Obenchain, you have something to say? Carol Foy.
Yes. So just in closing, with great power comes great responsibility. The gun industry must play a part in reducing gun violence. In every industry, they are held responsible for their products that they sell to the consumer, except for one. Gun manufacturers have been marketing weapons of war to children. They've made DIY kits to make ghost guns and refuse to implement practical life-saving safety measures, such as mass-producing fingerprint recognition. Lawsuits are one of the only tools citizens have to hold businesses accountable for products or practices that harm people not making their products safer. The threat of a lawsuit is a way for companies to take consumer concerns and safety seriously. The gun industry is above the law. We need to send a message, not now, not in Virginia. Everyone needs to play by the same set of rules. In every neighborhood, in every community, we all deserve to be safe from gun violence. As a mother of 2 young kids, I want what all parents want, to have my kids be healthy, happy, and not gunned down in the street, school, or anywhere. And our children deserve an opportunity to live.
Senator Obenchain, are you done?
I'm done.
Okay, thanks. Senator Obenchain.
Mr. Chairman, I understand what the patron is trying to do, and I respect our rather significant philosophical differences on the issue. This bill is designed to do one thing. It's designed to put all gun manufacturers in America out of business. And, a couple of things I would point out. It is written so broadly that it catches anybody and everybody with any association to a gun manufacturer, including the struggling mother or father who work as clerks in a gun shop or at any store that sells guns or ammunition. It would catch the person working at Walmart selling ammunition at the sporting goods desk. It catches any member of the print media who are struggling for advertising dollars. If the Richmond Times-Dispatch publishes a paid advertisement for a gun show, they are potentially liable under this bill. Virginia has gone to great lengths also in defining who is going to be held civilly liable for a criminal act of a third party. And this essentially declares, as a matter of law, that anybody affiliated with the firearms industry is automatically going to be civilly liable for criminal acts of third parties. I respectfully submit that if those who support this bill are successful, they're going to be successful in doing one thing probably more significantly than others, and that is creating one of the most robust black markets in America for the manufacture and sale of firearms that are going to come across our borders, which we have demonstrated of late that we are absolutely incapable of controlling in great numbers, and we're going to be fighting that fight. So, I think that there are absolutely legitimate ways that we can protect our children from gun violence. We need to be doing that. We need to be targeting the people who are committing crimes, not the innocent folks who are not foreseeably participating in criminal behavior. This is just the wrong way to do that, and I would hope that we would not move this bill along.
Thank you, Senator Obenshain. Senator Kilfoy, I think you're in good shape. Do you want to have a final word?
Yes, final word. I would just, Mr. Chairman, Senator Obenshain, I would just like to make reference to the fact that the automobile industry is thriving. They're doing wonderful. And after years of lawsuits being brought because their vehicles weren't as safe as they should be and fell below industry standard, we now have seatbelts in vehicles where we didn't have to before. And since then, automobile deaths have decreased by 50%. So it's really about ensuring that we improve industry practices. We hold people accountable for the things they put in commerce, and there are industry practices that have life-saving features that should be in practice. It's not in practice because they don't have to, and having some type of civil liability and not being above the law is one way that we get there. So thank you.
Senator McDougal wants to debate some more.
Mr. Chairman, the putting things into the stream of commerce and having people held responsible, we did not do that for drug dealers selling fentanyl when somebody dies. That was a policy decision this committee made. I just find it very striking that that's the argument that's being now used against guns. Drug dealers sell something they know is a substance that kills you, you die, and we don't hold them responsible.
Senator McDougal, I'm pretty sure there's language in the code that allows you to sue the drug dealer. I think we actually put special statutory authority in the code allowing you to sue the drug dealer, which is what this is about, is civil liability, not criminal, except for the public nuisance piece. So is there a motion on the bill? It has to go to finance for some reason. I don't. Okay, it's been moved and seconded by Deeds and seconded by Subramanian. We refer to finance. Clerk will open the roll.
Thank you.
Ayes 9, no 6.
Thank you. Senator Deeds has a witness here on 383, so we're going to hop to that.
383, and I'll just do it up here if that's all right. 383 is a bill that passed out of this committee and out of the Senate last year. It's a bill to make it a Class 1 misdemeanor to possess a firearm on a college campus. Chief Longo from the UVA Police is here. He's the one that really developed the bill. I think he testified for the House committee last year. I'm not sure that this committee had the benefit of his testimony. Come on up, Chief.
Yep.
Senator, thank you. Mr. Chairman, members
of
the committee.
MJ, why don't we set it for just 5 and 5 to be...
I apologize. We've got a substitute on the bill, and I would move the substitute.
Senator Deeds moves. Senator Subramanian seconds. It's substitute. All those in favor say aye. Anybody opposed? No. The substitute is before the committee. We'll set it at 5 and 5, 5 in support, 5 in opposition in case there's anybody else to testify. Chief Longo, welcome to the Senate Courts of Justice Committee. What do you have to say about this bill?
Mr. Chairman, thank you. Members of the committee, appreciate the opportunity to come before you today on behalf of the Virginia Association of Chiefs of Police and the Virginia Association of Campus Law Enforcement Executives. We collectively support this bill and respectfully ask that it advance accordingly. We think it's important for the following reasons. Number one, imposing criminal penalties for possessing firearms within the sensitive spaces of our institutions of higher education sends a resounding message that we value and seek to protect the lives of our students, our faculty, our staff, our visitors, and we honor the memory of those who have died at the hands of someone who deliberately and callously violated policy and used a firearm to take a life. Secondly, criminal liability brings with it the force of law that existing administrative policies fail to do. We believe that the existence of criminal liability and related sanctions may have a deterrent effect on those who seek to ignore administrative rules and further give our law enforcement officers the ability to leverage more appropriate and timely investigative and enforcement processes. Moreover, even if school officials were to act pursuant to an existing administrative policy infraction, there's no reasonable process in place by which a firearm can then be separated from its owner and retained pending further analysis and investigation. But when this is done for safekeeping, the retention period is short, it's temporary, and fails to prevent the weapon from being returned to its owner before a thorough and proper investigation is able to take place. And lastly, Mr. Chairman, much of the time, law enforcement, the enforcement of administrative policies within a university is left to persons with no law enforcement training or experience. Balancing a student, faculty, or staff member's Fourth Amendment interest against that of an institution can be a complex task that requires a good understanding of constitutional application and satisfaction. We believe that imposing criminal liability places the investigative and enforcement responsibilities in the hands of sworn law enforcement officers who are trained and experienced both operationally and with respect to meanings and application of standards of reasonable suspicion and probable cause, both of which are in place to secure the constitutional rights of individuals and properly guide the work of law enforcement. Mr. Chairman, I thank you for your time. I thank the committee for their service to the Commonwealth.
Chief, I think Senator Rubenstein might have a question for you.
Not really for Chief and the Chief. It's good to see you. I appreciate your being here and
appreciate
your advocacy. Questions really for counsel. Can't somebody already be charged for trespassing if there's a university policy and they are in possession of a firearm on campus in violation of that policy?
Mr. Chair, Senator Obenshain, I think it would depend if the institution had prohibited weapons and then if the individual, refused to stop the conduct or they tried to remove them because they had the weapon, then they could potentially be charged with trespass. But it would depend on the university whether they had that policy or not.
Right.
So, Chief, just to follow up on that, isn't the problem at least at UVA and I assume other schools that they don't currently have the authority to prohibit guns in their buildings, and so you can't use the trespass statute?
We do have administrative authority to enforce trespass. Chairman, what that requires, one is warning of and notice of trespass, the issuance of a no trespass order, and the person's noncompliance with that order. Then and only then are they subject to custodial arrest. Even at that point, the firearm in their possession is neither contraband nor evidence of a crime and therefore not subject to seizure. Even under circumstances such as a student where a firearm may be recovered in a dorm room or in a sensitive space, while that firearm may be retained temporarily, there's nothing under the law that prohibits that student from then coming to the police department and either getting their weapon back on site or filing a petition for replevin. There's simply no remedy in the law for us to retain that weapon while we conduct an investigation.
Okay, that's helpful. Senator Deeds.
And Chief, it's your view that if there's a rumor that a student has a gun on campus, you don't have the ability to get a search warrant unless there's a violation of the law. Is that correct, or an alleged violation of the law?
That's correct, Senator. There's no administrative warrants in the Commonwealth of Virginia for this purpose.
And so, Mr. Chair, Chief Longo, this is precisely the sort of legislation that needed to be in effect for you to have gotten a search warrant when there was a report that the young man who did the shooting at UVA had a firearm on his property.
Certainly, sir, if we would have had probable cause to believe that to be the case, we would have made an application for a search warrant. However, at the time, it wasn't a violation of criminal law.
That's right. Thank you.
Okay, thank you, Chief. So we have 2:23 left on the clock for those in support. Come on up.
If there's anyone online that would like to speak in favor of the bill, please raise your hand.
Go ahead.
Thank you. My name is Fallon Moore. I'm a senior at the University of Virginia and also an intern at Brady.
I thought everybody there goes by first year, second year, third year.
I was going to say fourth year, but I didn't want to confuse anyone. So I had both in my notes.
All right. Those of us that didn't go to UVA undergrad appreciate you're not using your language.
Thank you. There was nothing that could have prepared me for the night of the UVA shooting, which killed 3 members of our UVA family last year. It was 10:30 on a Sunday night when I received a shots fired UVA alert, followed by a text in all capital letters, "Run, hide, fight." There was an active shooter on our campus, and we didn't know where he was. For the next 12 hours, my roommates and I huddled in the dark together in lockdown, listening to a police scanner playing out loud. And we hugged each other and cried silently as we learned of the 3 students who lost their lives that night. It was a text from my dad the next morning after the shooting that made me reflect on how unshakable this tragedy would be. He said, "I'm glad he's caught and that you're okay, but I hate that your home there was made to feel unsafe." This is the unique aspect of a college campus and why it's so crucial to keep them safe. Our colleges are not just our schools, they're our homes. They're where we walk home from the library at 2 a.m. after cramming for an exam, where we gather in our arena for basketball games. And even now, just a year after the shooting, we feel more uneasy walking alone in the dark. We're wary of being in big crowds, and we jump at the sound of what could be a firework or a car backfiring, but could also be a gunshot. Our campus will be affected by this tragedy for a very long time, but this committee now has the power to keep firearms off of campuses, protecting our homes and preventing future tragedies. I, along with Brady, strongly support this bill. Thank you.
Mr. Chair,
Thank you for testifying.
I would point out that she missed a second chance to be pretentious there. She, instead of calling it the grounds, she called it our campus.
Again, another note I had. I didn't want to confuse anyone.
I appreciate that. I appreciate your story. My daughter was there with you last year and heard a lot about it from her as well. Know what you guys went through, but thanks for coming today.
Thank you.
Ms. Haas.
Good morning, Mr. Chairman, members of the committee. I wholeheartedly support law enforcement. Law enforcement needs the legal authority to protect their campuses, protect their students, and protect everyone on campus. When it's just a policy, which many universities across the Commonwealth have, they have no legal authority to do anything about this situation. We just really support the bill and thank the patron for bringing this forward.
All right, 15 seconds.
Thank you, Mr. Chairman. Moms Demand Action. I'm Lindsay Lang. Moms Demand Action also supports this bill. And as a student that was at Virginia Tech campus during the massacre that occurred there, it saddens me that we don't have these regulations in place to have possibly prevented what happened at UVA. Thank you.
Okay, sir, can you be quick?
Keith Conway, Gun Safety. I strongly support this bill.
Thank you.
Mr. Chair, there's one person online that would like to speak.
Okay,
Virginia,
online.
please unmute and make sure your camera's on.
And our time has expired, so you need to be super fast. Okay, that's quick. So let's go to opposition. 5 minutes. Mr. Van Cleve, come on up.
If there's anyone online that would like to speak in opposition, please raise your hand.
I find, Mr. Chairman, Philip Van Cleve, VCDL, thought that was interesting. The university's telling people in an emergency, run, hide, fight. Fight with what? It'd be nice if adults who have a right to protect themselves could do so in the universities. And so we strongly oppose this.
Good morning, Mr. Chair, members of the committee. Patricia Webb, Virginia Citizens Defense League. Just in case the question of Bruin comes up, there were some prohibitions on guns in colleges in the time period of the writing and ratification of the Second Amendment. However, those only applied to students. They did not apply to staff, faculty, individuals visiting the campus. So we'll just get that out of the way. I would like to point out also that the tragedy at Virginia Tech, that was a gun-free zone. It was not codified gun-free zone, but it was a policy of the school that it was a gun-free zone. So when the killer went in and locked the doors, chained them shut, it took extra time for somebody with a gun to come in and stop the massacre. And we've seen time and time again, and studies have borne this out, that when there's a violent attack, a mass murder, the perpetrator typically gives up when they are met with resistance. Typically, that's with armed resistance. However, when you create these so-called gun-free zones, what you're doing is advertising to evil people that there are defense-free zones where they can inflict major carnage before somebody with a gun shows up to stop their attack. You are creating dangerous situations and perpetrating events like the event at UVA or at Virginia Tech. I urge you to oppose this bill, and I thank you for your time.
Thank you. NRA.
Mr. Chairman, Taylor McKee, NRA. We oppose this bill because it codifies what is an administrative procedure by the schools, and we also don't agree with the expansion of sensitive places. Thank you, sir.
Thank you. Is there anybody online?
Mr. Chair, there's no one online to speak in opposition.
Okay, Senator Deeds moves, Senator Bagby seconds. The bill be reported referred to finance. Any further discussion? No. Clerk will open the roll. Bagby, there you go.
Ayes 9, no 6.
Great. We have time for one more, which I think, in that report, so we have time for one more, which I think will be quick, which is Senator, because it's mainly a finance issue more than anything else. Senator Perry, you have Senate Bill 356.
Yes, Mr. Chairman, members of the committee, this is Senate Bill 356. This is based off a jailer study for court-appointed counsel for indigent people. This is a long, ongoing issue where court-appointed counsel are...
Second. And report to finance.
Okay.
Mr. Chair, there's a substitute, I think, that is meant to...
Move to adopt the substitute.
Okay, it's been moved and substitute's been moved and seconded by Deeds and Open Chain. All those in favor say aye. Aye. Anybody opposed? No. Just so we're clear, is there anybody opposed to this bill?
It gives more money to Mark Peak.
Yeah.
The substitute just there were some class 6 felonies and things like that that were going to get the lower cap, and we raised. I went out and pulled some of them out, like or some of the manslaughter and some of those really complex cases that have a lower statutory maximum on there, but that would probably be eligible for a higher cap. I raised it for some of those lower level under class 3.
Hold on, are you in opposition?
It's a nuanced comment.
Okay, give your nuanced comment. We're supposed to be in caucus in 4 minutes, so come on, give your nuanced.
And Mr. Chair, just briefly, the substitute also accounts for probation violations in the various categories, so it adds language about how those will also be charged.
Okay, go ahead.
Thank you, Senator Servell, members of the committee. We support Senator Perry's concept here, but are very concerned that the way that the law is currently structured, the additional increase will be transferred on to the defendant. People are already being crushed with those costs, and this will continue to crush them.
If Senator Deeds has a bill that fixes that, we're going to hear probably Wednesday or
Right,
Monday.
I understand that, but that's obviously discretionary to the judge, and I think will be applied fairly differently across the state. And I think that's just a concern with this bill that we just wanted to have.
Fewer lawyers.
No, we do definitely support the idea of the bill, but just would hope that maybe the line could be struck that passes on the cost to defendants in this code section. Thank you.
I think we're going to take that policy issue up later, I think.
Mr. Chair, there's one person online that would like to
Is the person
speak.
online opposed to the bill? We don't need anybody in support.
Ramin, please unmute and make sure your camera's on.
No, he's not opposed.
Yeah, sorry, Mr. Chair. I support. Thank you, Senator.
Okay, thanks. Okay. It's been moved and seconded to report reader for the bill to finance. Clerk will open the roll.
I don't have the ability to vote up here. Can someone vote for me?
Yeah.
That's where you're going to go.
There you go. You should.
Thank you.
All right, folks, we had a
Ayes
big
15,
docket.
no 0.
Thank you, Mike. MJ, we had a big docket shaping up for Wednesday, Monday. Bring some snacks. Committee will rise.
Senate of Virginia.
Richmond, Virginia.